virtual mode.
Of the order dated 14/12/2023. The quorum was my Lord Justice Shadangi and my Lord Justice M.S. Raman.
I think, Mr. Rai had mentioned that yesterday.
Yes, that was a separate quorum. Review petition, but the separate one. This is.
Permitted to mention your lordships.
My lord, I am in virtual mode.
Contractor, he prevent to participate in future tender. They have blacklisted my lord without they have prevented to participate in future tender. My lord, without even a specific hearing to the petitioner, my lord. Prepare next week, my lord.
No, have you been blacklisted?
Yes, your lordship.
Yeah.
Next. 2 matters. Public.
Pardon to make mention, my lord. Here, my lord, on 1st of July 2024, this Honorable Court issued notice to the opposite parties. It's a matter arising out of a tender. After I deposited my performance security, they are.
Please.
So this on 1st of July, fixing the matter 2 weeks after. In between, I received a communication which they threatened to cancel my bid and appropriate my security. So that's why I pray for tomorrow or day after.
Day after.
My lord, that's it. No, I have already filed a miscase to that effect. And I have mentioned the miscase number
He's
here.
on the other side.
My lord, for railway.
So please inform him.
My lord,
Please seek his consent then. Please seek his written consent, then we will do this. If he declines, then also.
My lord, I am in virtual mode, my lord.
Yes.
should I, may I just, may I make a
My
mention?
lord, I am in virtual mode.
After
launch.
at 12. Yes.
My lord, item number 55 of page 36 is a nursing matter, my lord.
Yes.
That in the nursing matter, I have already filed a counter. They have filed rejoinder. So because of my high operation, let it be taken up next week. I have taken consent of all the councils.
All right. With the consent of the other side, this is for request.
My lord, it may be, my lord, it may be taken up next week, Monday or Tuesday at the convenience of the court.
Wednesday.
Tuesday, my lord.
Wednesday.
Wednesday. Oh, bless.
Huh?
Oh, bless.
Tuesday.
Not in the press contempt, my lord. Second time I have filed it before DR. I have mentioned
Press
several times,
contempt
but
filed
not
second
till
time.
Friday, my lord. Taken out Friday.
Please let us understand. First, second, press contempt filed second time.
My lord.
So what do you want?
Well, not listed up. Time had my lord before DR. I have filed memo several times, but not yet listed, my lord. But Friday taken up.
What order can be passed in the contempt matter?
That order was not complied, my lord. It's the second time.
What order can be passed in the contempt matter?
But due to non-compliance, my lord.
We are asking what order can be passed in your contempt matter.
Punishment.
Suppose we take up your matter tomorrow, then and we decide that we are of the view that there has been violation of the order.
Order is violation, my lord, for that punishment and
Sorry, contempt matter is not urgent.
This Friday, my lord.
Sorry.
Second contempt, my lord. Order is not complied, my lord.
Sorry.
In spite of what is order, my lord? There is order for eviction, my lord.
All right. Sorry.
Lordship, one restoration application CMAPL of 2023 fresh. The quorum is of the Lordship and RK Patnaik.
DB.
My lord.
DB.
Division bench, my lord. The Lordship and Justice RK Patnaik, my lord.
To mention, my lord, this is a restoration of writ application. The writ application is dismissed for the non-prosecution.
By which bench?
Lordship, division bench, lordship.
Of?
RK Patnaik, lordship of this honorable court. Several times we have. Yes, lordship. Yes, lordship. Yes, lordship. Several times I will submitted in the DR lordship. I will listed tomorrow, lordship.
There is 3 phrase writ petition, your
This
lord.
is writ petition, Mr. Counsel. No. Restoration of writ petition.
Yes, lordship.
When was what is the year of the writ petition?
Uh,
2012.
12.
And there must be absence of.
So due to communication gap, the petitioner did not provide instruction to the council, for which he had submitted the no instruction. The lower court passes an attachment order, your lordship, against the petitioner.
We will see.
Lordship, there is 3 new writ petition, phrase admission, your lordship. It's about grant of NOC.
No, but why are you filing the writ petition? They are automatically listed.
Your lordship, the urgency is the last date of grant of NOC is 15th of July. Lordship, the matter has been not been listed yet. Maybe, lordship, Friday, and 2 other matters are on yesterday, lordship. The urgency is the last date of issuance of NOC is 15th of July, your lordship.
So the timeline has been fixed by the court.
Yes, your lordship.
So there is a process for each step we have
Lordship,
prescribed the timeline.
your lordship, due to some administrative lethargy, the petitioner is suffering. Lordship, that's why we are filing this writ petition.
There is no question of.
Maybe listed, your lordship.
Why?
Grant of NOC, your lordship.
NOC, madam, NOC has to be granted by them. For each and every step, the court has fixed a timeline with strict instructions that they cannot deviate from that without the leave of the court.
But your lordship, due to their lethargic, the petitioner is suffering.
What is lethargic and how are you suffering?
Lordship, for that academic session, he is unable to admit the pupils, your lordship.
Have you applied for NOC?
Yes, your lordship, I applied.
Within time?
Yes, your lordship, within
Then
time.
what happened thereafter?
Thereafter, your lordship, they did not communicate it to us. And we didn't find, when we went physically, then we found out the matter, the last date of NOC, and thereafter we came to this court, your lordship. Exactly, your lordship. Tomorrow may be listed.
Give you.
Tomorrow may be listed.
No, they did not learn about some certain.
My lord, I have contacted the railway council and he has consented for tomorrow. Mr. Satya Kashyap is the railway council.
Published.
Wait, please, your lordship.
Just 1 hour.
Terms of the last order dated 19th June, the district education officer Angul has filed an affidavit online, but that is not there in the file. I have filed the hard copies today.
Filed it online yesterday or today?
Actually, today.
Today. Oh, no, because we are trying to find out what is the use of filing online if it doesn't come on the record. So if it is today-
Actually, it is today morning. But we have short copy on the petition. Para 3 and 4 is the response to the order of the Honorable Court.
Have you seen?
My lord, I just got a copy of the affidavit, my lord.
Yes.
My lord.
So what do you want?
My lord, regarding the status of the underpass that they were say to facilitate.
That is
the-
also there. That
Yes,
is
ma'am.
the last annexure, your lordship may see. The last annexure. Annexure
My lord, the
L by 7, page 9. Page 9 of my affidavit. L by 7. No, my lord.
He stated that the
The
contractor.
contractors, the Sri Vigneshwar contractors, that is.
New school
My-
Parapur, they have said.
The underpass is page 10.
Yes. Yeah, I'm sorry.
Yes, they are doing, Mr.
In progress means what? In progress system is where?
When the demolition was in 2021.
NHI. NHI. Yes,
The earlier affidavit my lord filed NHI, the Kala, the competent officer filed, that is up to plinth level. Now it is lintel level, that is just below roof, some portion is there.
Building.
Yes.
The building. Okay, then you can. This is matter after 3 months.
And 3 months लगेगा?
No, 3 months full.
They are saying that they will be completed within 3 months.
My lord,
So we'll list the matter after, say, 8 weeks
my lord.
to see the
Latest
progress and thereafter.
We'll file, we will come up with a current status of that with photo. The
And about
NHI,
about the
Malal-
underpass.
NHI will, your
My
lordship
lord,
may
the
direct
photograph
the-
earlier to filed in underpass to the officer who has gone
What
to
is the
other duty.
status?
My lord, given that photograph is not properly visible, but that is they have
No, what
almost
is the
completed the.
status? What is the status? You are saying that you are constructing some overbridge to
bypass.
Bypass, my lord.
overbridge to facilitate
Underpass,
construction
my
of
lord.
underpass. Just a minute. This is what is there in the counter affidavit filed on behalf of the estate, that they are in the process of construction of an overbridge to facilitate construction of an underpass.
Right.
This is what is there in the.
Under only, yes, ma'am.
Over-
Yes, correct.
The photograph not properly visible, but the passages are there, but not completed.
But how much time will it take?
My lord, the officer, he has gone to Rathayatra temple duty, but he is over telephone. I said that he is trying to 3 to 4 months will complete this.
This is the one.
This is one.
Yes, that is.
Pillar and roof level has been completed. The
This is
ending
very satisfied. You will see after 2 or 8 weeks. Two additional affidavits have been filed. One on behalf of the district education officer, Angul. And have you also filed affidavit?
my lord, I will file complete.
An affidavit. So an affidavit has been filed on behalf of the district education officer, Angul. Today in the courtroom, which has been taken on record, first off, we had been informed that the said affidavit has been filed online also. So it has been stated in the additional affidavit that because of construction of NHI upon partial demolition of school building, study of students in class 1 to 5 of Kisorganj Primary School has not been adversely affected. So, the students are attending their classes in the rest of the 5 classrooms. Basic amenities like toilets, drinking water, kitchen, and 1 office cum staff common room is available in the school. Stop. It has further been stated that the contractor, Yara Masti, what is the contractor or what?
Contractor.
That the contractor, that the concerned contractor has been asked to complete construction of new school building for the said school within 2 months.
Within, Malad, 3 years,
3
3
months.
3 months. Page 9.
Yes,
Malad, 1
within
right.
2 months. This is what you have said, within 2 months. So, however, the contractor is said to have intimated the status of the stage of the construction of new school building and has committed to complete it within 3 months. So stop. It has also been stated that construction of an overbridge for facilitating construction of an underpass to cross the national highway is in progress. So stop. Learned counsel for the NHAI has submitted, next paragraph, counsel for the NHAI has submitted upon instructions that the overbridge with underpass shall be constructed within 3 to 4 months.
Fine.
So stop. List this matter on 8 weeks. Let additional affidavits be filed on behalf of by the DO and on behalf of NHAI stating further progress.
So far as the underway is concerned, the NHI will.
Yes, sir. That is my lord.
So far as the underway is concerned, the affidavit has to be filed by them.
Therefore, we have indicated.
No, DO, your lordship has
No,
said
no,
that DO will.
NHA,
DO and NHAI.
my lord, director
Yes.
NHA.
By the DO and on behalf of NHAI. This is what we have stated. One affidavit has been filed by the DO and another affidavit on behalf of NHAI.
Yes, ma'am. Yes, ma'am.
Item number 2.
Or we can ask one of the students to come to this court to understand the ground reality on the next. We'll see. The next.
My lord, this writ appeal is referred against the judgment of the Honorable Single Judge, where the applicability of the 1974 rules has been was accepted. The Honorable Single Judge held that 1974 rules are applicable to the persons, to the employees under the block grant payment. That is under challenge before my lords. The delay was condoned on 1/5/24, and my lord seniors they have already appeared. I pray, my lord, this matter may kindly be taken up along with WA 6445 of 24.
When is that matter coming?
My lord, I'm sorry. That is WA 197 of 24. 24, ma'am.
WA 197 of 25.
Another, my lord, WA 713 of 2021.
Yes.
Another writ appeal, WA number 713 of 2021. Connected matter.
So order challenging same order.
No, my lord, it was challenged by another writ petition on order, honorable single judge held that the suspension order is valid and the additional district magistrate being the present, the order of suspension is legal and valid and in accordance with law. That has been challenged by Mr. Rautray in that writ appeal. Again, same writ application was filed that was allowed.
What is the question involved in this case?
Question is involved, my lord.
Please hear the appellant. Yes.
Yes, let him.
Well, the question involved is whether the provisions of the Orissa Education, Recruitment and Conditions of Service of Teachers and Members of the Staff of Aided Education Institution Rules 1974 shall be applicable to the employees governed under block grant. That is the question. Now, the writ petition was filed, the present writ petition was filed challenging the suspension. Now, my lord knows the suspension under the 74 rules, there are certain provisions as to how a suspension order is to be passed and it is to be carried out, with how approval is to be taken. Now, our stand before the Honorable Single Judge was 74 rules is not applicable. That's how the Honorable Court came to, my lord, because of the rule itself. Because of the rule itself. Now, that stand was negatived by the Honorable Single Judge. That's why we are before my lords in a writ.
Same point is involved in.
Yes, ma'am. The question is this: whether this rule shall be made applicable.
When do you want?
My lord,
though Honorable Single Judge held that 74 rule is applicable, in final order, the Honorable Single Judge held that this 74 rule is not applicable in the present case. Same point. Different. Whether suspension order can be passed by the order 74 rule.
my lord, may I kindly fix up the matter for any date after.
Does this matter 1 week? Along with WA number?
My WA number 713 of 2021.
21.
Yes.
And 197 of 24.
197 of 24 is similar to my return.
Yes.
I don't know what my senior is mentioning about 21 appeal.
21, Mr. Rautra has filed.
This judgment is
Out. That is another one.
That is the Honorable Justice Vishwanath Ratha has passed the order.
Let this order be decided.
My lord.
First, we will consider your writ later.
Now, that is also in respect of that similar
We
matter.
understand.
Arising out of same cause of action.
No.
No, same cause of action. Another order was passed.
Same cause of action.
Yes, my lord.
What is this?
No, same, my lord, on same cause of action, the Bajenti Naik
Can you distinguish between same cause of action
No,
and
not
same
in
point
respect
involved?
of the appeal, my lord.
Why do you use this such expressions? Same cause of action. What is cause of action?
Three causes of action are there, my lord.
Unnecessary.
Same cause of action, my lord, in that the suspension was passed, order was passed. Item number 3.
Item number 3, a big apology, my lord. May I pray for some of the day, my lord, my learned senior, Mr. Das, has some personal difficulty. Some of the day, my lord,
Respondent number 1 is 88 years old. Now your lordship has been pleased to pass an interim order staying the order of the Honorable Single Judge permitting transfer of land. Now, if he has difficulty, my lord, your lordship, I am
Only
praying,
2 days I am praying.
Maybe-
For, my lord. Next week, any date your lordship may fix.
taken up on Monday, my lord.
Yes, I don't know.
Because, my lord, my lord, that day, my lord, because they had not filed a date chart, my lord, they took time to file a date chart today.
It has been ready, my lord. I'll file.
Will file. Don't file.
I beg apology. I beg apology.
I
I beg
have-
apology.
I have prepared a date chart, I will assist your lordship, my lord.
As requested.
I pray, my lord, your lordship may take up on.
Additional decision matter on Monday.
Oblige.
Great.
Obliged.
Item number 4.
May I please, Your Lordship? Here the opposite party number 2 in the writ petition is the appellant herein challenging the order passed by the Honorable Single Judge. Here the matter relates to promotion by opening the sealed cover procedure. Now the impugned order is at annexure 3. My Lord may kindly turn to page 105. Page 105, annexure 3. Order starts from page 107. Relevant person is at page 109.
You are challenging which order?
This annexure 3.
Annexure 3 is an interim order.
No, this is the final order. Though there is no mention that writ petition has been disposed of, but entire relief has been granted by that order. Nothing remains to be decided in the writ petition.
So you are challenging 14/5/2024 order?
Yes, yes. My Lord may kind down to page 109, paragraph 7. May I please? In such view of the matter and the ratio laid down by this court in WPC number 33216 of 2021, especially paragraphs 27 and 28 of the order dated 7/12/2022, this court is of the view that the petitioner be given promotion with immediate effect, subject to the final outcome of the vigilance case. The case of the present petitioner be considered within 1 month from the date of the presentation of this order. Well, here, in fact, this order which was relied upon by the Land Council for the petitioner, was challenged by the state government by filing writ appeal. Well, that writ appeal is at page, my Lord, you can see page 129. Annexure 5. That is the case status, my Lord, you can come to. Now, top is the writ appeal number 596 of 2023. Page 129, annexure 5. This is the case status downloaded from the registry. And we can see top. Writ appeal, then next below is 596 of 2023. Yes, it is disposed of. Now, my Lord, may kindly turn to the bottom. Bottom of the same page, the heading is main matters. Same page towards bottom, just heading is main matters. One column before the last column. Heading is main matters.
Yes.
My Lord, towards right, my Lord, we can see it arises from WPC 33216 of 2021. Well, this writ appeal was disposed of by a common order at page 131. Page 131 is a batch of writ appeals.
Annexure 6.
Yes, ma'am. And this 596 appears at page 138, serial 38. Page 138, serial 38. WPC, WA number
So whether
596.
this order was brought to the notice of the single judge?
Well, in course of hearing, that order was produced and relying upon the statement of the Land Council for the writ petition, this order has been.
Did you bring this
No,
order, this decision of the court to the knowledge of
No.
the single judge? Then you could have sought modification or something. Why are you challenging?
This is the entire relief has been granted.
Entire relief, you can say that relief has been granted without noticing a division bench of this court, division bench decision of this court. Why the court should interfere? The court was not aware of this order of the division bench order.
That order which was relied upon, that has been set aside under annexure 6.
Huh?
That has been set aside under annexure 6. Yes, no, because there was no occasion. So in course of hearing, that order was placed.
Mr. Counsel, in course
Yes.
of occasion, if that was done, you could have filed a review application. You could have filed an interlocutory application.
Your Lordship may grant me that liberty so that I can file.
Counsel appearing on behalf of the appellant, assuming the impugned judgment, impugned interlocutory order as order dated so and so, person so and so, has relied on a division bench decision of this court in case of annexure 6 and batch paragraphs 12, paragraph 11, 12 and paragraph 11 and 12 of which read thus. Stop. Learned counsel, however, admits that the said decision of the division bench was not brought to the notice of the learned single judge. Stop. In such view of the matter, he seeks leave to withdraw this writ appeal with a liberty to apply for modification of the modification / recall / review of the order impugned in the present appeal. Also, this appeal stands disposed of accordingly. As withdrawn with the liberty as sought.
Item number 5.
May I please? Lordship, last occasion, Lordship directed the filing of counter. Lordship directed twice in 3/4/2024 and on 26/6/2024. Lordship
What is
twice.
the matter?
Matter about a 200 construction of a 200 feet urban road, BDA road, in infringement of BDA Act and rules, Odisha Development Act and rules. And it infringes and also transgresses into a Gram Panchayat area. An urban road transgresses into a Gram Panchayat area, thereby.
Yes, why are you not filing affidavit?
Your Lordship will be filing it tomorrow, Your Lordship. We've received the instructions. Tomorrow we'll file the affidavit.
Last sentence, otherwise.
Council and AGA representing the state of Odisha submits that the counter affidavit shall be filed by tomorrow after serving a copy upon learned counsel for the petitioner. Stop. In such view of the matter, list this case on 2 weeks. Stop. Learned counsel for the petitioner shall have the liberty to file a reply to the counter affidavit, if so required. Yes.
Item number 6.
Item number 6, I filed one interim application for adding the steel and mining department as a party. They are the now nodal agents for granting the lease. Let them be, my lord.
So that is not there on record.
My lord, I have filed today in court, my lord.
The learned counsel for the petitioner
They are
states
file counter.
that an application has been filed for implement of
Steel and mine department, my lord, state of Odisha.
implement of steel and mines department to secretary.
My lord.
To its secretary. Full stop. You said.
This is not been filed.
You are not filed.
My lord, I filed it today in court, my lord.
No, file it in the registry.
Yes, 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 yes,
You
yes.
have not filed online.
No, man.
Oh. File it in the registry, not here. As a question on behalf of the. As requested on behalf of the petitioner, this matter on 1 week.
Item number 7.
Item number 7, my lord, I'm filing an affidavit today for withdrawal, my lord, with the liberty, my lord, when your lordship had, initially heard, the lordship was of the opinion that it's an association who has filed it. There may not be a cause of action. So, my lord, I'm only praying that a liberty that any direct promoter having cause of action may.
For the petitioner, after some argument, seeks permission to withdraw this merit application. This application is this has withdrawn. So we however make it clear that we have not addressed the issues. We have not gone into the issues raised in the present writ petition filed on behalf of which is this association is filed on behalf of an association. First off, it will be open for an individual to raise the issues which have been raised in the present writ application in case any cause of action arises.
Grateful.
Item number 8.
Lord, we are the postgraduate students of radiology in the department of government has issued guidelines on dated 29th January 2024, where government sought for an application for 6 months training program. After that, my lord,
Is PIL?
no, my lord.
It's not a PIL.
No, my lord.
Then why has it been listed before division bench? Why the matter has been listed for division bench? Technical education.
Has challenged the virus of the rule.
Oh. Which rule?
Where
There is no challenge.
Your lordship may say,
PNDT Act, my lord.
Looking at the prayer.
PNDT.
issue an appropriate order direction in the nature in permitting declaring that action for but in synopsis she has said for that reason it is. Your lordship may say, see the synopsis.
Oh, familiar to rule 7.
Yes.
Bad in law. Not very.
Not properly worded.
Oh. Without ensuring proper infrastructure and faculty, then there is.
No, they are not challenging rule.
In fact, in
Yes,
the
ma'am.
prayer portion, there is
Challenging
no.
Rule 11, ma'am.
Challenging?
Rule 11, ma'am.
Prayer.
Compliance of providing. You are asking for.
7, 8 and, yes, my lord.
So please read your prayer. Then it means.
Yes. Issue an appropriate order of direction in the nature of declaration in permitting declaring that the action of opposite parties for course of training without ensuring proper infrastructure and faculty as contemplated under provision rule 7 of preconception and prenatal diagnostic techniques rules 2014.
You are not challenging any rule.
Yes.
You are challenging the action.
Yes, my lord. As per the rule of 2014, under rule 7, 8, and 11, I'm emphasizing on rule 11 now. Kindly have a glance to
So rule
annexure.
11 is correct or not?
No, my lord. Proper faculty was not there to give training to the.
No. Absence of faculty is a different thing.
Yes.
Provision is a different thing.
Yes.
So according to you, provision is good, but that is not being followed.
Yes.
This is what you want to say. This is,
Providing the infrastructure.
you have started these courses. This is your grievance.
Yes.
Who are you?
I'm the aggrieved PG students who are practicing in radiology department, and under rule 11, my lord, as per the guideline on annexure 1, page 34, kindly have a glance. After the first paragraph, note below, my lord. Intake of candidates will be on the basis of 1:4 PG teacher and student ratio. The PG teachers of Department of Radiology and O and G can be the faculty for such training. If the PG teachers be the faculty, kindly have a glance to next to annexure 2, my lord. Page 40. Rule 11. Staff faculty. The institute conducting the said 6 months training for registered medical practitioners shall appoint the postgraduate teachers in radiology or obstetrics or gynecology recognized by the respective regulatory bodies as full-time faculty for the said training program. If the PG teachers be the full-time faculty of 6 months training program, then our PG course will be hampered, and we have given our grievance under annexure 3, 4, and 5 by the.
What is this program? 6 months program?
Yes.
Page rule 3.
Ultrasonography fundamentals of abdominopelvic ultrasonography level 1. Grievance. Yes.
Your grievance is if your teachers are deputed to conduct this 6 months training.
Yes.
Your studies will be affected.
Yes. And in my grievance under annexure 3, 4, 5, the postgraduate PG
So
students.
when were you admitted?
Bhimsar College, Burla. And I do not have so much.
No, but you might have completed because it's only 6 months.
We are continuing our PG courses.
No, 6 months.
Postgraduate course. 2 years.
Oh, you are being asked to take classes of that course.
No. Yes. Yes.
Teachers were supposed to teach you.
Yes.
Are being deputed for conducting this.
Yes.
Our studies are getting affected. So our teachers are being sent for this. Will be sent. Has this course started? The 6 months course has it started?
Yes.
I will take instruction on this.
No, it's not.
DMT. Yes.
Who will get instructions?
I will get instruction. Yes.
Well, in the read petition enter his grievance is that rule 11 of that rule is not followed. Well, ultimately, rule 7 and rule 11. It is not their case that they are affected.
No, they may not be affected. But now the matter has come to the High Court.
Yes, ma'am. It is their case that rule 7 and 11 not followed. Well, ultimately, rule 7. That
39.
yes, served a copy without paging some.
Yes, I will get.
Ultimately, rule 7. Accreditation of institutions for 6 months training and its recognition. The following teaching institution would be accredited at training centers to impart the 6 months training, namely Centers of Excellence established under the Acts of Parliament, Medical Council of India recognized institution offering postgraduate program in obstetrics and gynecology or radiology, institution offering full-time resident DNB program in obstetrics and gynecology or radiology. The names of the institute recognized for shall be notified by the state-wise by the State Health Medical Education Department, provided the training is recognized for imparting the 6 months shall maintain the standard of infrastructure, equipment, and manpower, including the faculty as apex regulatory body like the Medical Council or the National Board of Examination. Then we will also see Rule 11. Staff faculty. The institute conducting the said 6 months training for registered medical shall appoint the postgraduate teachers in radiology and obstetrics or gynecology recognized by the respective regulatory body as full-time faculty for the said training program. Then my guideline was issued. You will also see the guideline. Guideline in accordance with Rule 7, guideline has been issued. You will also see guideline as Annexure 1. It starts from page 31.
Yes.
You'll also see page 33. Name of the accredited institutions for training. All these are the government institutions, madam.
For that, you have to apply the school time.
All you'll also have seen that read petition. In that read petition, nothing has been mentioned. In these institutions, the staffs are not available in accordance with rule 11.
File an affidavit.
Yes,
See,
yes, ma'am.
This is for 2 reasons.
Madam.
We don't know how adversely the deputation of their teachers would adversely affect their teaching. But if you don't follow the
Rule 11.
Any of the provisions,
Either 7 or 11.
Then the genuineness of that course itself can be doubted.
And also standard.
So even if no standard, question may arise. The institutions like MCI may decline to recognize your.
These institutions are government institutions.
Maybe government institutions without following the rules.
Yes.
You are granting. So those are regulatory bodies.
Yes, ma'am.
Regulatory bodies will say that you did not have the regular faculty.
I understand, ma'am.
That is the reason. Otherwise, it is semi-PIL.
Yes. In fact, it is a PIL.
4 weeks' time is allowed for the state or the opposite parties to file counter affidavit.
And a copy may be served on DMT. Mr. Swai, who is appearing for DMT.
Requisite number of copies of the petition be served on learned counsel representing DMT by tomorrow.
Ishwar Chandra Swai.
So our anxiety is.
I understand, Mel.
Yes.
May I please, Your Lordship? The petitioner is before Your Lordship because even though he has emerged successful in a tender, the same is not being granted, work order is not being granted to him, and the same is being deferred from time to time. And this is tainted by ill intention against the petitioner. The ill intention against the petitioner is borne out by a judgment delivered by this honorable court, wherein the petitioner was blacklisted for reasons which were untenable in law, and that was struck down, my lords. Your lordships may take page 120 of the brief.
No, but what can the court compel them?
Well, here, yes, the court can compel them because if it is not, they have just have stated here in paragraph Para 10. Para 10 of my writ petition at page 6, the petitioner have come to know through reliable sources the matter was discussed in 2 consecutive meetings dated 13/2/24 and 14/3/24, and it was advised by the committee that since an SLP has been preferred before the Honorable Apex Court against the judgment dated so and so, they unanimously decided for further developments in the same before issuance of the work order. And though SLP has been filed and a notice has been issued, no stay has been granted. And my lord, that does not mean that I will be left without my source of livelihood because just because they have filed an SLP and no interim stay has been granted.
There is an order of this court on 17/5/2024.
Well, I have taken instruction, my lord, through phone, my lord, over phone, my lord, because in due to pendency of the SLP, my lord, in the SLP, my lord, delay was condoned and notice was issued. And thereafter, the SLP was numbered, my lord. And now it is admittedly pending, my lord.
You are supposed to give the instruction if there is any interim order.
How, my lord? And your lordship, very interesting. Kindly see page.
Mr. Counsel, if that is the reason,
My lord.
then your action is tainted with
No, my lord, that is not the lordship. Can see page 130 for
you can take a plea that we have decided not to go for the whatever, if it is
my lord,
or whatever. That is different, we may decide.
But
if you take this plea, that it is because of the pendency of
no, my lord, that is not
before the Supreme Court and therefore work order is not being issued, then yes.
My lord, no.
And that is one aspect.
My lord, we will file a counter affidavit. My lord, we have not filed any counter affidavit. My lord.
Please come to your paragraph 10.
Sorry, my lord.
Paragraph 10.
Yes, ma'am.
Please read it.
Yes, ma'am. That the petitioner came to know through reliable sources that the matter was discussed in 2 consecutive meetings dated 13/2/24 and 14/3/24, and it was advised by the committee that since an SLP has been preferred before the Honorable Apex Court against the judgment dated 22/8/23.
What is the effect of such a statement? It has come reliable sources to your knowledge, and then you have read paragraph 10.
Yes, ma'am.
And then come to your affidavit portion.
Yes,
the declaration.
Yes, ma'am. Yes, ma'am. Affidavit in para 3 stated the contents of this writ petition be read in part of parcel of the present affidavit and not repeated. The annexures filed so and so. Para 5, the facts stated above mentioned writ petitions are true and correct to the best of my knowledge and information derived from records.
What report?
My lord, I have had the occasion
and then come to declaration. Below that you have stated something like declaration. I don't know what is that. 1 to 7 of the writ application are true to my knowledge and facts, and paragraph 1 to 17 are correct to and true to the best of information which I obtained from record, indicated in annexure. So your petition can be dismissed on this ground alone.
Well, this I'll correct. This declaration I will correct.
Do it.
It has,
Do it.
in fact,
Otherwise, see,
eh,
other than your statement in paragraph 10,
yes,
you
madam.
have no case.
Yes.
And the statement made in paragraph 10 has no basis.
That I will correct.
That we don't
I
do.
get your lordship's point, but the issue is,
No
madam,
issue, no issue. Say, just see, we decide, the writ petitions are
I,
decided.
I absolutely bow down to that, my lords. I do accept that there has been a mistake on my
It's not
part.
question of mistake. Even if you say that if there was a meeting held, when was that meeting held? And you reliably learned. How do you reliably learn? You can disclose the source. What was the discussion, part of the discussion in that meeting? You know that also.
Well, it's the fact of the matter is that my client has been,
That is, you are right.
because
Let
there are
them
certain
take
things
this
which are
plea.
not brought on
Let
record
them-
because they
let
are
them-
internal
All right,
communications, but
first
they
of all-
are in the
first of all-
public domain.
First of all, correct your.
I will do that. My lords, the matter is urgent because for 1 minute, my lords, if your lordship will only take page 90.
Not even a single mistake.
Your lordship may call this matter on Monday. In the meantime, and have the corrections done.
Tuesday.
Monday, my lords. Your lordship may call.
Tuesday. I have requested on behalf of the commissioner. Let it matter on Tuesday.
May I please your lordship? The petitioner has challenged the order of the Central Administrative Tribunal passed on
Hmm?
22/4/2024, my lord.
What is the order? Or you're
Your
affected
lordship,
by what?
page.
Annexure 5 series.
My lord, page 60, starting from 60, my lord. Relevant portion, last portion of the order, that is the page.
Yes.
67. The case of the respondent rejected the candidature of the applicant for the post of PGT, para 11, my lord. Since the applicant did not possess the educational qualification, the applicant seeks this tribunal to interfere in rejection of the candidature.
You are reading what?
Para 11 of the order, page 67.
Yes, you are there. Yes.
In this case, the respondent rejected the candidature of the applicant for the post of PGT since the applicant did not possess the educational qualification. The applicant seeks this tribunal to interfere in rejection of its candidature on the ground that the applicant has studied mathematics in all the years of graduation, but has not produced any such evidence to substantiate except the mark sheet, wherein prima facie it reveals that he studied mathematics for 2 years and secured 30 marks out of 100 marks for 2 years only. This is forfeited by the certificate issued by the Sambalpur University, stating therein applicant has studied mathematics as core subject during first and second year. Further, the certificate also shows that he has passed the BSc examination without honors. As noted above, since the eligibility qualification for the appointment of...
So what is wrong?
My humble submission, my lord. The eligibility criteria, your lordship kindly turn to page 30. Page 30, my lord. Applicant should, your lordship, get page 30. That is the notification where
30.
30.
Yes.
The eligibility criteria, my lord. The applicant should have studied mathematics all the years.
So you want to teach mathematics?
Yes, my lord. PG.
You please don't spoil career of the students.
No, my lord.
Yes.
30
Don't do
out of
this.
100.
Even if you are qualified, you should not be.
No, my lord. My humble submission, because lordship, he has a science graduate.
Please, science graduate, you scored 30 in
Mathematics.
first year out of 100.
2 years.
Your lordship,
We will not allow you.
Your lordship, kindly turn to page
Please be kind to
22. That is the final election, because he might have suffered due to his illness. He could not have secured mark, my lord.
Alright.
But
He might have failed.
He might have failed because of some ailment. and
My
therefore-
my lord,
No, no.
he has to appear a LDC examination.
Okay, just one moment. What you read out from the order, you've studied maths for 2 years. But that says you should have studied for all the 3 years.
I am
Sorry, all the years of graduation. You are +2 or BA, BSc?
BSc.
BSc.
Yes, my lord. BSc honors, but honors, yes,
No.
without honors, and the mathematics is as a core subject.
Sorry.
So once he has passed the BSc, so core subject, that is means first year, second year, one examination, and final year for examination. And the marks submitted, that is the first year, second year, one examination, and the final examination for final. And he has passed the BSc 3 years degree course.
Do you understand?
Now they have said that you have.
What is the evidence that you had studied mathematics in all the 3 years? Do you have any evidence?
Your lordship, kindly turn to page 53.
Yes.
This is the certificate issued by.
Please read it.
This is to certify that the Nilakantha Mishra bearing the justice has passed Bachelor degree of Science without honors, 3 years degree course examination 2004.
There. Yeah, I asked you whether it is BA or +3. You said BSc. So
Yes,
BSc is 2 years. 3 year is +3.
Yes.
That means you should have studied maths for all 3 years.
3 years.
But your discussion by the tribunal says that you've studied for 2 years.
Now that is the wrong for which I
Anyway,
have approved.
all right, you please continue.
Your lordship, kindly see, he has passed Bachelor of Science 3 years degree course examination.
That's all right.
Yes. And
Studied maths or not?
my lord?
Studied maths in all the 3 years or not?
Yes, my lord. Your
Where
lordship,
is that? Where is that?
your page 22.
No, that 53 as a core subject.
My lord?
That certificate, which
Yes,
you
ma'am.
say,
That 53 page, your lordship. Next, as per prevailing syllabus, regulation at that time, there were provision of 2 examinations. One for first examination and other is final examination. The first examination covered subject paper taught during first academic year and second academic year of 3 years degree course. Further certified that the applicant studied mathematics as core subject during first year and second year.
so,
And he has,
so that last line.
my lord, and he has, because
Please, this certificate. What
Well-
is the last line of that certificate?
last line.
Last line.
Yes, he has said that he has studied first year and second year.
Yes.
My humble submission, yes, he has not mentioned because he has passed the final examination. First year, second year examination was one. Thereafter, final examination. Once he has passed final examination, so far as first examination is concerned, that is for first year, 2 years. That is why he has mentioned specifically.
So what was your score in first year?
My lord,
What was your score in first year of examination?
your lordship, kindly turn to page 22.
All right.
That is first examination. That is 142 mark. 142.
142 first
Yes,
year.
madam.
Second year?
This is for first year and second year, one examination.
Yes.
First year and second year, one examination.
Yes.
Then final year, that is, they have given
So
a core subject 167
Out of?
out of 400. That is the mark I have annexed, my lord. That is at page 22. So you will see,
50%.
Where is that? Let us see.
my lord,
Where reading?
page 22,
Page 22.
my lord.
Page 22.
But still it is risky. Oh,
No, he has to appear a competitive examination, my lord, if you qualify that. But now the eligibility
No.
criteria, that's
Let us see.
This is the post of what?
my lord,
Post.
TGT, trained graduate teacher.
Where is that? Page 30. Which page you are referring to?
For the page 22. Marks for page 22,
22.
my lord. Your lordship, total final mark
Just a
examination
minute.
Yes.
or core subject final examination 162. Then honors first
No, no,
examination.
where are reading? Page 22.
Yes, my lord.
Just a minute.
Last but 5 lines, my lord. Total honors final examination. Thereafter, total core final examination.
Core 2 mathematics, paper 3 and 4.
Yes, that is for final examination.
30.
Yes, my lord. But for first core first examination, he has
first examination. First examination, thereafter,
Where is the first examination?
just bottom.
Bottom,
Total honors
first examination.
400. Total core final examination 162. Core examination first paper and second paper. Next, total honors first examination. Thereafter, total core first examination. That is 400, 140.
Sir, you are thoroughly incompetent for taking up this teaching job.
No,
You were a student of BSc honors. You could not do your BSc honors because of your poor performance.
but after that,
You haven't
he
declared
joined
BA
as
pass.
a private
Sorry.
teacher since 2009.
Sorry.
And in 2009, he has joined.
Oh.
Now the issue whether he has completed in all the years, he has passed studies mathematics in all the years or not. That is the issue, my lord.
A thoroughly bogus student. And the fate of the poor children.
No, my lord, he has already developed because he joined in
do something
2009.
else.
Thereafter, for the
are so
fourth
right.
ADC exemption for 2021.
No. If this is your mark, what will you teach the students? And a subject like mathematics.
My humble assumption, if your lordship will not, there are
Your submission is that time he had not done well, now he has improved.
because after some years he has studied, he might have developed and he may appear, because he will not be promoted unless he qualifies the LDC
Let us
exemption.
understand again. What is your, how do you say that you studied mathematics in all the 3 years?
Yes, this is the mark sheet where first exam, they have given first exemption and second.
Where?
Your lordship kindly, page 22.
Yes.
Passed Bachelor degree of Science, 3 years degree course. He has passed Bachelor of Science honors 3 years degree course, examination 2004.
Yes.
Thereafter, your lordship, 3 years they have said, so and first examination, that is serial number 1, 2, 3, 4. Your lordship kindly see. Total core first examination, 400.
Where
Yes,
are you reading?
bottom of the mark sheet.
Yes.
After underline 1, 2, 3, 4.
Yes.
Total core final examination. Your lordship, total core final examination.
Where? Where
The
is
bottom of the mark sheet, my lord. On page 22.
So go slowly. So that is the fourth. First says total honors final. Then
Yes,
it
ma'am.
says total core final. So
Yes.
which are you referring to?
Thereafter.
Total core final.
Total core first examination.
Okay. Total where? Total core first examiner. That means that the fourth line.
Yes, my lord.
Yes.
Fourth line,
Out of 400, 142.
my lord. That is the first examination, second examination.
But
Yes.
what is total core?
Total.
What is the meaning of total core?
Total 2 core subjects.
Yes.
That is chemistry and mathematics.
All right. So CHF is chemistry.
Yes.
CHF is short form for chemistry.
My lord, chemistry.
All right.
Chemistry and mathematics.
All right.
And physics, he was taken physics honors, but though passed, but without honors. Without honors.
So paper 3, 4. Paper 3, 4 will be in the second year.
Final examination. That
No,
is the
where
your
exactly
lordship kindly.
that
Just
he studied mathematics in first and second year?
Sorry.
Where
That
is
was
that?
another certificate. Where is that certificate given by the university about what you have studied? Which,
now
is,
the certificate.
which itself is confusing. Page 67 of page 53.
53.
Page 53.
My lord. He has passed Bachelor degree of Science without honors, 3 years degree course examination 2004.
Yes.
From the
With
Sambalpur University.
mathematics as a core
Mathematics
subject.
as a core subject.
As per
As
the
per
prevailing
syllabus
and
and regulation at that time,
All
there
right.
are provision of 2 examination. One, first examination and other is final examination.
There is no ambiguity.
My lord.
Last sentence clear.
Oh, exactly. That he's saying is a mistake. It's a mistake. What to do then? The first mistake.
First examination covered.
Second year.
The subject papers taught during first and second academic year of 3 years degree course.
All
Further,
right. Sorry.
That last line is against you.
yeah, no, that is not my excuse because it has clarified that first examination he appeared on first year and second year.
Sir,
That we have
the
understood.
last sentence you read it loudly so that everyone in the courtroom may understand what you are saying. Please read.
Further, it is certified that the Nirakantam Mishra applicant has studied mathematics as core subject during first year and second year.
It should have
He
been.
has not mentioned third year only because he has already mentioned that he has passed Bachelor degree of Science,
All right.
3 years course.
All right.
So once he has passed 3 years course and there are two examinations, first examination and second, final examination.
All right.
And for
You
first,
forget your case. If you would have seen this a certificate, what would you have understood from that last line?
from the last line,
That
for
you
first
studied
exam-
mathematics for first year and second year.
Yes.
That is the normal understanding. So the certificate, if it stands, you can't
And
get
also,
any
I have
benefit from
produced
this.
the certificate, my lord, which has been issued by the university, where he has given marks for two examinations, first examination and
Where
final
is the
examination.
advertisement?
Advertisement is or requirement.
Yes, my lord. Advertisement, my lord. Page
No.
25, my lord. Where 20, page 33 is the eligibility criteria for PGT math.
Okay. That is very clear. Chemistry. So these are the optional subjects.
Petitioner in the presented
May I
application.
submit one thing? Let the Sambalpur say that I have not studied 3 years for BSc, my lord, because 3 years course, my lord, and plus 3. Your lordship, kindly.
Petitioner in the
Visualize.
presented application has put to challenge an order dated 22/4/2024 passed by the Central Administrative Tribunal on Cuttack Bench, Cuttack in OA number 672 of 2022, whereby the petitioner's application has been rejected. Stop. From the, it appears that the petitioner was working as primary teacher which
Kendriya Vidyalaya number 2.
My lord.
at Koga Gugu, sorry, at Bolangir. At Bolangir, KV1 Bolangir. primary teacher at KV1 Bolangir. Full stop. A notification was issued on 2/11/2022 inviting applications for filling up various posts, including the post of PGT bracketed mathematics through limited departmental competitive examination bracketed LD-CE. Full stop. The petitioner had though the petitioner's candidature was not recommended. Full stop. Not recommended, whereafter he had filed certain representations before the authorities. And thereafter, he approached the approached the tribunal seeking a direction to the respondent opposite parties to consider his case for appointment as TGT. Full stop. It is worthwhile mentioning, where is that advertisement?
Page 23, advertisement. 25.
30, eligibility criteria is 30.
What starts where?
Start.
Yes.
Page
For the
25.
post of TGT maths,
Annexed A by 3.
following was the qualification prescribed. Following, comma, inter alia, comma, was the minimum qualification prescribed. Page 30. जो column है, column 2 का सब. The applicant should have studied math. ठीक है? Full stop. The tribunal, after having considered the stand taken on behalf of the opposite parties in their counter affidavit, has concluded in paragraph 11 as 11 as under. Full stop. Next. Then counsel appearing on behalf of the petitioner asserting the order passed by the tribunal has attempted to convince this court that the petitioner had pursued 3 years BSc honors in physics course, but passed BSc bracketed without honors, and had studied mathematics in all the 3 years
As core subject.
of the course. Stop. The said submission advanced on behalf of the petitioner is not substantiated by any document on record. Stop. Rather, where is that certificate? What, 2 years?
That is at page 53.
The petitioner himself has relied on. You had filed this before the tribunal.
Yes,
Annexation
certificate.
certificate you had filed.
Yes, ma'am.
the petitioner himself had relied on a certificate issued by the Controller of Examination, Sambalpur University, issued on 27/2/2023 in support of the claim of his eligibility, which has been brought on record by way of not part of an action, which is available on record. Stop. The last sentence of the said certificate reads thus. Last sentence, page 53. Stop. Next. In view of the document which was relied upon by the petitioner himself before the tribunal, it is apparent that he did not fulfill the eligibility condition of having studied mathematics for all the 3 years of the BSc course. Stop. The finding recorded by the tribunal as regards the petitioner's ineligibility does not suffer from any legal infirmity. Stop. We do not find any merit in this writ application, which is dismissed. No orders as to cause.
My humble concern that they have said that he has passed bachelor degree, 3 years degree course, my lord.
No, but they've clearly stated that you've studied for that. May be a mistake on their part, but this is clear from that. We can't read anything beyond that.
My lord, but he has passed and given marks, my lord, for a year, and without studying he has.
See, the biggest mistake committed was that you relied on that certificate.
And also I am relying the certificate, marks, my lord. I am also
No,
relying
they
this.
have- Whatever rightly or wrongly, they have clarified that you studied for 2
I
years.
have also relied the marks issued by the university.
All right,
They have also relied two exams. They have given two marks.
yes, sir.
May I please, Your Lordship? Now, the petitioners are presently working as level B assistant teacher, ex-cadre in different primary school. Here, the petitioners have challenged the order that notification dated 22/12/2016 under Annex 3, my lord, wherein they have been declared as level B assistant teacher ex-cadre, my lord, which is contrary to the Odisha Education Elementary Rule 1997 and RCFC Act
No,
2000.
where is that? What are you
Lordship,
challenging?
Page 81, my lord. Lordship, may come
Page 81.
Lordship, page 84, sorry, my lordship, may I come to Annex 3, page 84. Sorry, my lord.
Yes.
Well, this is the modalities for regulation of Gana Shikshaks, my lord.
No,
Lordship,
but why have you come to the division bench? Yes.
my lord, similar matters are before the division bench, and my lord, in one matter, my lord, in WPC 189/188 of 2022, my lord, pleadings have been completed and it is fair for final hearing, my lord, before the division bench, my lord.
All right. Please, this. So
Lordship.
you are challenging Annex 3.
Yes, my lord. Annex 3, lordship, this is the modalities for regularization of Gana Shikshak, my lord. Lordship, kindly have a glance at point number 1. The Gana Shikshak who have been completed 8 years of regular and continuous engagement and have possessed educational and training qualification as mentioned at para 2 below will be regularized as level B assistant teacher ex-cadre, equivalent to level B teachers of elementary cadre. But this is the expression ex-cadre which I am challenging, my lord, because in the elementary cadre, my lord, there is no provision of ex-cadre. And my lord, as per RCFC Act also,
Just a minute. So what is the difference between cadre and ex-cadre?
But ex-cadre, my lord, will not be promoted, my lord, will not get promotion. And my lord, they have relied upon this elementary cadre. The Odisha Elementary Education Rule 1997, there is no provision of ex-cadre, my lord. Lordship kindly have a,
Forget ex,
my lord.
for ex-cadre, there is no requirement of any rule. Ex-cadre or cadre, there may be requirement of any rule.
Yes,
other
ma'am.
rules or something. All right. Person working in a cadre
Yes, my lord.
can be sent to a post which is an ex-cadre post. All right. If there is a cadre in which you cannot fit in,
Yes, my lord.
then your cadre can be treated to be an ex-cadre.
Yes.
All right. Say in case of dying cadre,
Yes, my lord.
if no further recruitment or if that is there and in course of time
Yes.
it is required to be abolished, then such decisions are taken. Those posts are treated to be ex-cadre.
Yes.
All right. So there is no. This is one aspect.
Yes, my lord.
The other aspect, there are two other aspects.
Yes.
One, how do you claim that you should be part of this elementary teacher cadre under
Yes, ma'am.
which provision?
Yes, my lord.
Yes.
My lord, kindly have a glance at our resolution basic upon which we are appointed, my lord. Lordship, that is page 81.
Yes.
My lord, we are initially engaged as Gana Shikyak. Thereafter, we are regularized, my lord. Lordship, kindly have a glance at point number 5. The Gana Shikyak will be engaged against the existing created vacancy of the Shiksha Soyaks, and their consolidated remuneration, etc., will be borne out of SSA budget. Well, we are engaged against the existing vacancy of the Shiksha Soyak, my lord. Well, Shiksha Soyak post is a cadre post, my lord. When Shiksha Soyak are regularized in level BA, my lord, that is a cadre post.
So you want to be in cadre?
Yes, my lord.
So then remain in Shiksha Sahayak?
My lord.
Shiksha, what is that?
No, we are already regularized, my lord.
Still.
Where is your regularization? First,
My
they
lord,
say
kindly have a, my lord, for a moment, kindly have glance at point number 5. The Gana Shikyak will be engaged against the existing created vacancies of the Shiksha Soyak. My lord, we are engaged against the existing vacancy of the Shiksha Soyak. My lord, Shiksha Soyaks are regularized after 6 years of service. We are also regularized, my lord.
So you are different. You form a class. If you want to be in cadre, then remain in that Shiksha Sahayak or whatever you call.
you must have been initially engaged as education volunteer.
Education volunteer.
Thereafter,
the scheme was closed. My lord, the scheme was abolished,
yes,
my lord.
so
Thereafter, we are.
different schemes to different scheme ultimately have become Gana Shikyak.
Shiksha Soyak and Gana Shikyak.
That is why they are giving you this.
Shiksha Soyak and Gana Shikyak.
So this is the only thing which you want.
My lord.
This is the only thing which you want.
Yes, my lord. My lord, Shiksha Soyak and Gana Shikyak post is created from same my lord scheme. Sarva Shikya Abhijan scheme. And my lord, similarly situated Gana Shikyak, who have earlier approached this court, my lord, they have brought into the cadre fold. And that is a judgment I have given, my lord, in Dhananjay Charan Day case. That has also been confirmed by the Honorable Apex Court, my lord.
Give that, we will see.
And my lord, similar matter, my lord.
No, we will decide this then. Similar matters, we will decide.
My lord, in that matter, my lord, counter regent, both have been filed, my lord.
Without counter, it can be decided.
Well, in that matter.
Why? Is there any compulsion that petitions would be dismissed after filing of the counter affidavit?
No, but in that matter, pleadings have been completed, my lord. That is.
No, here your pleadings we are listening.
We will see.
Is it true that other matters are pending on the same point?
That
We'll come back after recess. You check and tell us. He's giving some number.
give me the.
WPC 18918 of 22.
Same issue is involved, we will think.
I'll
Yes,
check.
you checked. We'll come back.
I'll check. 11.
Just verify. Similar matter, the last order that is passed in 2023. It has been indicated no counter filed, but my learned friend is saying that counter has been
The
filed. then I'll
counter
have
pleadings have been completed, my lord.
So tomorrow we are.
Yes, yes, my lord.
Yes.
Tomorrow it will come, and in the meanwhile, tell us how many cases.
My lord, more than 20 cases, my lord.
All right, give us the list. These are not very complicated issues.
Yes, my lord.
What is the number?
18918 of 2022.
18918 of 2022.
2020.
And if there are other cases, you can give.
Yes, my lord.
Others have been tagged with that.
Yes, my lord. There are a batch of
So
petitions.
that is the lead case. As
My
far, or, I mean, all cases are tagged together, that is one of the cases.
Yes, my lord.
Mari dekh le, bahar pe kya number? Nahi? Please give the other numbers also.
Yes, my lord. I will give.
At lunchtime you give it.
Yes, my lord. Obviously.
Tomorrow.
Item 12.
Miller, the petitioner simple writ application filed before this honorable court. Your lordship, the opposite part number 2 and 3 did not listen the petitioner's case as the opposite part number 4 forcibly encroach the
Public road,
yes
apply.
land and the public road.
We have decided
Yes, Miller.
that if any there is encroachment on a public land, then there is a procedure prescribed under the CRPC. Which Panda? Pinnath Panda. Pinnath Panda judgment follow.
Miller, the repentation may be disposed of.
Sorry.
The
that-
constructing the
that is
house.
the last thing which this court will do.
Miller,
There's a
Miller, the opposite part number 4.
you decision in Trinath Panda that is being disposed of. Along with that, you approach the magistrate. All right, because encroaching on the public road is public nuisance. So accordingly, you are
Also Gochar land of the village.
saying
Gochar
public
land of the
road.
village.
Again, you are saying Gochar.
Everything is there.
Item 13.
Item 13, my lord, may be permitted to withdraw.
Item 14.
The item 14, the similar matter has already been heard and judgment is reserved.
What is that?
That is the issue regarding the block grant orders, virus of the block grant orders, which was challenged, a batch of cases. My lord was extensively heard and reserved for the judgment. Did this matter come thereafter?
2 weeks.
Mal.
This is matter after 2 weeks.
Mal.
In the meanwhile, let us know.
It was before vacation, my. It was before vacation, your lordship had it.
Item 15.
May I please, your lordship? But here the petitioner, my lord, had applied online applications for a grant of new no objection certificate in respect of GNM course for the academic session 24-25, my lord. In the meantime, after receiving the statutory fees, my lord, by the annexure 3, annexure 2, the DMAT intimate us to comply certain deficiency. By the annexure 3, you have complied within the time period since March. Till date, they have not issued any NOC. And in the meantime, my lord
Till
was
date,
after
they
that,
are not required to issue NOC.
your lordship has fixed the time. As per their request, they had filed interim applications where my lord was fixed. The 15th will be the last date. In spite of, they have not yet done.
What in spite?
15?
Date has not yet come.
15th July, my lord, this.
So what is the date today?
Today is, my lord, 10th.
So this is before 15th or after 15th?
15th, the last date for grant of NOC. Before that, they have to give the, my lord.
Give the what?
They have to inspection, online inspection.
Okay.
It takes 1 hour.
They may do that.
They have not done it. That's why I have
So
approved.
why everything should be done on for 10? Or
That's
before
why,
10?
because your lordship, after your lordship judgment, they come up with the interim applications. They have come up with the revised guidelines.
All right.
As per the revised guidelines, your lordship has stipulated. They do it within
So
the
what
time.
has not been done in accordance with the guideline?
Inspection and grant of
Inspection,
NOC.
is there any date fixed and the
Yes,
guideline?
lordship has seen. Your lordship has fixed.
What is the date? What is the date? Tell us.
So here, my lord, issue of NOC by the concerned council by 5 PM, 15th July.
15th July.
Yes.
So what has not been done which was
Before
required?
that,
What has not been done which was required to be done by 10th of July?
they have not yet intimated for inspection at least.
Is there any direction that inspections should be intimated by 10th?
Prior to that, my lord, that says 30th June is the final decision for approving and disapproving for inspection.
That will be done.
That has been extended
this
till
is
15th.
Premature.
No, 15th is the grant of NOC.
The 30th June?
30th is for approval. Whether they are approving or not,
No, that 15 July is for affiliation and that has been extended, sir. What I got the information, but I have a short instruction, my lord, maybe taken up on next week. I will give
Which,
the
what has been
detail.
extended?
For affiliation from
Affiliation is different.
different.
Next date, if it
Yes,
comes next
yes.
week, the date will have gone.
Yes, gone.
They will be they won't be left with any remedy.
What happened to their case, I will
Tomorrow.
Tomorrow.
maybe
No,
Mr.
no.
Bhunesh.
You have to think of the institution, not your convenience.
No, no.
No,
Their
you just
institution
tell
is
us. Just tell us whether you are going to take a decision on 15/7/2000 or is there any problem?
Yes, ma'am.
See, you are not required to seek any instruction other than the fact as to whether some decision is going to
Yes,
be
yes.
taken.
The process of inspection is going on, my lord.
Why this is
They have-
premature?
Because number of institutions, they have given time, but institution we have applied since December, my lord.
So
They have not
No.
taken any tangible
They
steps.
are worried that you have not given them a date for inspection.
That is the problem.
whether they have complied with the deficiencies or not in time or that.
Let them consider, find out.
For that reason, I want next Monday or Tuesday.
Tomorrow, all you have to do it, you can get
Just
it
tell
over
us.
tomorrow.
Item 16,
I have already solved the copy, Malini, in advance.
16.
Lords, here, I'm a leaseholder, my lords. I am applying for giving me Y forms, which are essential for transport of minor minerals. But irrespective of my representations pending from December, as well as the last one issued in the month of May, no action on my representation is being taken. I have a very small and innocuous prayer. I cannot even challenge any decision because they are not
That
taking.
small and innocuous prayer we decline.
Milords,
We will not issue that order.
Milords, if they don't issue, I am having a leaseholder. I am having a lease.
See your rights.
Yes, Milords. Milords, may see. Milords, may see. Annexure 18 Milords. Annexure 19 Milords. At page 114. I had initially come before this honorable court. A demand was raised on me, and that demand was stayed subject to I depositing 30%.
See, this is how you obtain orders from the court. Then also your prayer was innocuous to dispose of the representation, and now again you are seeking the same relief.
No.
Dispose of the representation.
There was not for representation. My Milords may see just the page before that. Milords may see annexure
So this is
18. There, Milords may see annexure 18.
yes.
Milords, there a new additional charge calculation came in, which was subsequent to LOI being
Alright,
issued.
tell us the facts.
Yes,
from
yes,
the
ma'am.
beginning.
Milords,
Briefly.
2014, auction notice was preferred, Milords. I participated in auction. LOI was issued in my favor. Initially, a lease deed was executed with me. The lease deed was subsequently cancelled because of NGT orders. Now, in the meanwhile, I approached the Honorable Apex Court. Apex Court said that because I am not a party to the NGT proceeding, the order was stayed. Thereafter, on their instructions, I withdrew the application for the Apex Court. Thereafter, they said, at Annexure 16, they say that you deposit 46 lakhs a mod and we will take appropriate steps towards executing lease deed. Immediately, they again changed their stand that they asked me 1 crore 49 lakhs. The reason why they asked for 1 crore 49 lakhs is introduction of another new tax that is called additional charge, which is subsequent to my LOI. Now, my lords, once the additional charge comes in, they say you deposit that. I approach the High Court. That is the order that I was showing, my lords. The High Court says as an interim, this honorable court says that as an interim, 30% if you deposit, that is the admitted due, 46 lakhs amount, it is the admitted due. Then you can go ahead and get the lease deed executed. I got the lease deed executed. I deposited 30%. They in the lease deed say that for the second year, all amount is paid. Additional charge will be subject to the outcome of the writ petition. The writ petition is as on date pending.
We will take up
Yes.
this matter along with WPC number
25793.
25793 of 2023 on 2 weeks.
Item 17.
Let's 2 weeks minutes.
Madam, may I please, Your
Much
Lordship?
of this minutes.
Madam, my case also stand on the same footing of the item number 15, just one before my learned friend's case, Mr. Das was arguing, relating to granting of new NOC in respect of the nursing institution. Your Lordship made a query on that. Miller.
Mr. Counsel, the difficulty is
Miller.
that the court laid down
Miller.
clear-cut guideline
Miller.
within which they are required to take decisions.
Miller.
Now, within that period, just for the purpose of filing your writ applications, you are filing writ application, then do it.
Your Lordship approved the 2019 guidelines. I have annexed it, Your Lordship. I can appreciate me, Lord. It will clear Your Lordship. It will clear our case before Lordship. Your Lordship, in Your Lordship comprehensive judgment, sitting with Honorable Justice Raman Miller, has approved the NAC.
Subsequently, we have modified that order.
Yes, Miller.
Yes.
That, however, that 2019 guidelines issued by the Family Health and Family
What do you want?
Miller.
What do you
Miller,
want?
as for the guidelines itself, Your Lordship, kindly appreciate page 37. My running page, I have annexed.
No,
the
you are
guidelines.
arguing which matter?
Miller, 17, relating item number 17, relating to
17
granting
also.
of.
Yes.
Miller.
Yes.
Your Lordship, kindly appreciate page 37.
Yes.
That is the
Yes.
part of Annexure 6, that is the guideline of 2019.
See, to get over this situation,
Miller.
we may have to dismiss one or two writ applications as premature. We will consider consider your rights after 15.7. Before 15.7, we are unnecessarily entertaining.
Miller, they are under the obligation, Miller.
Mr. Counsel, which part of the order has been violated? Tell us. Which part of the order?
Miller, 2019 guidelines.
Forget guidelines, see the order.
Miller.
Everything is there in the order. Which part has been violated?
My Lord, I'm just placing Your Lordship. I kindly appreciate. I have quoted Your Lordship judgment in my writ application, Miller. Your Lordship has specifically mentioned that there should not be no violation of 2019 guidelines. So, as per the 2019 guidelines, Miller, it is under their obligation, Miller. It is the obligation after compliance of the deficiency, they would go for inspection, Miller. And as per the inspection, Miller, another 1 month time is to be led to the institution for fulfilling of the deficiency. That is under the guideline. Now, Miller, Your Lordship, time is approaching. They have not inspected our institution. 15 is the time limit of Your Lordship. That is our sole predicament, is that to that extent. Your Lordship, as per Your Lordship judgment, they are not fulfilling it, Miller. That is our grievance. I have already laid down in my pleading to that extent, Miller. That is my grievance. Your Lordship has been pleased to fix up the other matter.
No, we will decide. We committed a mistake in that case. We will decide this case.
Miller, that is my predicament. That is sole predicament. Your Lordship may kindly appreciate the relevant portion of the guideline. Should I read it out for Your Lordship kind appreciation, Miller?
We are the authors of the guideline. So we know,
Miller,
what are there in the guidelines.
Miller.
There is no difficulty about that. We will decide your grievance.
Miller, my case is pending before them, Miller. Then my apprehension is that we have spent a course of money, Miller.
We have understood what you are saying.
Miller.
But put up for judgment out of tomorrow.
Item 18.
May I please, Your Lordship?
And Mr. Please tell your officials that if the court finds any deviation, then the court shall be very heavy on them.
So tomorrow you come ready with instructions.
Yes.
May I please, Your Lordship? Pursuant to a auction sale notice, the petitioner participated in the auction for a sand seller, became the highest bidder,
and an agreement has been executed on 26/2/2024 under Annexure 5,
26 to
2024.
agreement. Then what happened?
Thereafter, the order was issued on 22/3/2024 regarding operation of the Sand Sarat. I have deposited, I will take your lordship to page 50, Annexure 8, where it has been mentioned, with reference to the subject cited above, I am intimate that you have said source, your above said source has already been executed since 26/2/2024, and you have obtained all statutory document, that is approved mining plan, EC, consent to establishment of consent to operate, so and so.
What do you want?
I have started the operation, but abruptly on 22/6/2024, they have directed you have violated clause 51(1), 51(4), 51(7) of Odisha. My lord,
51?
clause 50, rule 51(1) I, 51(4) and 51(7) of Odisha Minor Mineral Concession Rules 2023. So you are directed to suspend mining operation immediately from today onwards till completion of final report on joint inquiry, further orders. If found you are involved in excavation of the leasehold during the suspension period, then your action will be treated as criminal action. Necessary steps will be taken against you for each act as per the law. My lord, as per the approved mining plan, I am to excavate 5,553 cubic meter of sand from the sand sarat per annum.
Where is the impugned order?
Impugned order at page 54, Annexure 10. And 51(7), sorry.
Yes.
Clause 51(7) provides of the Odisha Minor Mineral Concession Rules, in case of breach of any condition of the lease deed, the competent authority may give notice of 60 days to the lessee to rectify the defects within the time specified, and if the lessee fails to rectify the defects within the specified time.
No, where is the power of suspension?
There is no power of suspension under these provisions, 51(1)I or 51(4) or 51(7). Rather, 51(7) provides if there is some irregularity. Your lordship, I am reading 51(7). In case of breach of any condition of the lease deed, the competent authority may give notice of 60 days to the lessee to rectify the defects within the time specified, and if the lessee fails to rectify the defects within the specified time, the competent authority may cancel the lease and or levy penalty not exceeding rupees 50,000. I have deposited about 85 lakhs, and the period is a fixed period from the date of execution of the agreement. The time will run, and the water will come in the river. It is a river Baitarani. After 1 week or 2 weeks, due to the monsoon, I will be unable to operate the mine. This is the peak hour. I have spent a huge amount, deposited about 85 lakhs. Now I have been without any authority of law. They have prohibited me from operating.
After all, my lord, this is the appealable order, my lord, because appeal lies under rule 46, my lord. Rule 46, your lordship mechanism.
No notice, nothing, sir.
46 mile.
This notice says that a joint inquiry was conducted on 21/6 in your presence.
prior to giving consent,
1 day before.
1 day before,
What consent?
prior to providing an opportunity, providing the handing over the site for operation.
On 21st, this is just the previous day the inquiry has been conducted in your presence. Then they found something wrong, that's why they've asked you
My
to
lord,
suspend.
if it's allowed, then nothing will remain to inquire.
Joint verification has been made on so and so comprising. There is nothing,
1 day before.
no report. no-
1 day before that.
Yes, that
In your presence, it was done. They found something wrong. That is why they asked you to suspend and they will conduct further inquiry.
my lord kindly will have a glance to page 53.
Yes.
Your lordship, what is the quantity I have lifted?
That is
The
immaterial.
total is 588. That is, this is
That
your
is not
front
this.
page, annexure 9. It is their portal. I am to excavate 5,553. They monitor it through their web portal. This is the report of their web portal. And total I have excavated 588.
See, web portal is not the physical thing.
Right.
Physical thing can be seen on physical verification only.
Right.
So web portal may be reflecting something different than the actual. All right. So-
Suppose, my lord, there is
So it
maybe
was
some
done
little
on the basis
variation.
of
My lord,
verification.
that there may be
No,
little variation.
No, web
Still-
portal is as per the documents. Joint inquiry, field inquiry.
As per the field, my lord.
Actual
My lord, the total quantity is 5,553. I have,
No, that we are not going into because there's
Yes,
nothing
yes.
there. They are not alleging that you have done excess
my
mining.
lord, at least Rule 51(7) provides, if there is anything wrong, then they have to give him in writing and they will provide me a time.
They'll give
I
it.
will rectify myself.
They'll give it.
They have not given it.
They may.
No,
See.
that is not, my lord.
Till
Your lordship,
completion
page
of final
54.
report.
This report has not been given us. I am replacing in full, my lord.
No, that's last paragraph. Please read it.
So you are directed to suspend mining operation immediately from today onwards till completion of final report on joint inquiry. They have contemplated the report.
Yes. Where do you have the power to suspend?
No, my lord. In fact, my lord, there are some illegalities, my lord, some allegation is there. So unless he is suspended to operate, otherwise the further inquiry is no meaningful, my lord.
Why?
Because he will manage to lift, my lord, because there is allegation of illegal,
Where is the power to suspend? Because of the lease, he has a right.
my lord.
So his right, how can you suspend that?
My lord, in violation of terms and conditions of the rules.
Where is that power of suspension?
Is it there in the lease deed? Have
My
you
lord.
stated?
My lord, in the lease deed, my lord.
Where?
Is there any
No,
power?
no. Cancellation.
Cancellation, suspense.
No suspension is there.
All right. Even if you suspend,
My lord.
then can you guarantee that for the period during which the operation remains suspended,
My lord.
that period shall be extended?
No, in fact, my lord, he has to lift a particular quantum of sand, my lord, within a particular year.
Suppose for your
Because that
for your
quantity is fixed, my lord.
inquiry,
My lord.
what we are asking, suppose for your inquiry, you take 15 days.
My lord.
He's not able to do mining for 15 days.
My lord.
Ultimately, it is found that everything is in order.
My lord.
What will happen to the 15 days he has lost?
No, we may extend, my lord, because in fact, my lord, that the quantity is fixed, my lord. Within a year, he has to lift, my lord.
Really, how can he lift? You have stopped him from doing.
My lord, we'll
And
extend,
then forget that.
my lord.
Where is your power to suspend?
My lord.
Come ready tomorrow.
My lord.
There are two
My
aspects.
lord.
Your power to suspend
My lord,
You can take a plea that because you have right to grant, therefore you have
my lord,
power to suspend that
my lord,
also.
my lord.
But there is another aspect. This order does not disclose anything. You have been establishing minor not in accordance with rules. What not? What has he done?
In fact, my lord, there is a mining plan and
So
there
you
is,
should, that should,
my
that
lord,
should
my
have been
lord,
mentioned.
that must be
in the order.
specific, my lord,
So there is nothing in the order.
my lord,
You examine and otherwise.
my lord, my lord, my lord,
Otherwise, the appellate provision will not apply.
my lord, my lord.
The provision for appeal will not
My-
apply
my lord.
because if that is passed by a competent authority,
My lord.
competent authority, sorry, if no person has authority to suspend them, no, there's no.
Mining officer is the competent authority here, my lord.
No.
Tahsildar is no more competent authority.
No, he is incompetent.
What is this order?
If the suspension,
My-
if he does not have the competence to suspend, then he is incompetent.
My lord, my lord,
Therefore, he is incompetent authority
lord.
to suspend.
my lord,
Tomorrow.
my lord.
You also examine whether there is something, some power to suspend or not.
Item 19.
May I please your lordship? My lord, here your lordship, petitioner is one of the successful bidder for a stone quarry in the year 2022, your lordship. After the bid work was over, I was issued a letter by the opposite party number 4 to submit my letter of acceptance and some other deposit to EMI and some other fees, your lordship. Accordingly, I deposit all the fees, and thereafter I was directed to execute a agreement with the opposite party number 4, and also directed to pay something for clearance of the environmental clearance or some other fees. Accordingly, I paid all the fees, your lordship. All the fees before the opposite party number 4 in shape of the DD.
When 2022.
In the year 2022. Thereafter, your lordship, I awaited for the marking of the stone quarry where it was. But due to mismatching of the revenue record, that particular stone quarry was not identified by the revenue department. Accordingly, in the year 2024, due to help of the geological department, that particular stone quarry was identified. Thereafter, the environment department has issued a memorandum, official memorandum to follow the NOC. Thereafter, he issued the clearance certificate to operate the stone quarry, your lordship. Till then, from the 2022 to 2024, I have not operated and did extracted a single stone from the quarry, your lordship.
Maybe you must have identified in the meanwhile. They might not have been information.
No, I have not operated for a single. Thereafter, your
File
lordship.
your affidavit.
My lord.
But
This
your
is
lordship,
also applicable.
There is a demand notice was issued.
This is also applicable.
Demand
This is
notice
also
was issued.
applicable, my lord.
Is there any order?
My lord.
Where is that?
Lordship kindly see that demand. Annexure poll mod page 36.
I'm placing.
So you can.
Page
file
36,
your
my
appeal.
lord. This is demand.
The demand without operating any
So you can challenge it.
Yes, I have challenged it, your lordship. I first submitted so many different.
No, you challenge this order before the.
Authority, your lordship. My lord, kindly peruse the page, my 37, next page, your lordship. Next page.
Provision for
37.
deposit.
I represent, I go to with the knowledge of all the authorities. I have not operated, they know. But how the input notice was issued by the opposite party number 3?
You can go, you can.
My lord, give you the liberty, your lordship. Till then, no
Counsel
course
for-
of action.
No, Front counsel for the petitioner after some argument seeks permission to withdraw this writ application with the liberty to question the legality of the demand notice dated 5/4/2024 bracketed annexure 4 under section before the appellate authority under section 46, rule 46
My lord, rule 46.
of the Odisha minor mineral rules. So stop. This application is accordingly disposed of with the and as withdrawn with the liberty as sought. So what is there any limitation?
Limitation 30 days, my lord. Let him file, my lord.
Oh, limitation has not
My lord,
expired.
within 90 days, there,
Limitation,
my lord, liberty.
it is made clear that if any question of limitation arises, considering the time then the petitioner had approached this court by filing present writ application, the appellate authority shall liberally consider any consider any application for condonation of delay if the appeal is referred within 15 days.
Within 15 days.
Within 15 days from today, and decide the appeal on merits
Miles.
within a reasonable period of time.
Humble submission before Lordship. Till then, till the pending disposal of the appeal, because I have not operated your Lordship. That may be considered. This way
Item
we
number
cannot-
20.
That is impermissible.
Obliged.
Minor. Urgent certificate copy.
No other than certified copy.
Sorry. Sorry.
Huh?
No, nowadays, within 2 days, order is available in the website. That's why my lord saying it is not necessary.
Practice your Lord, general practice. I beg apologies for that.
This is the matter relating to non-renewal of NOC for the same nursing school.
Yes.
Here is a case of renewal. It's an old institution and we have submitted all documents. Might there for inspection. He's not coming for inspection.
They may do it. They may.
Tomorrow, all right.
Tomorrow we are going to, tomorrow, no, we are, in fact, we are not inclined to entertain such.
No, my case is for inspection.
We understand
All
that
these are for inspection.
everything has to be done before 15 July.
Obliged.
They will be doing it.
They are not doing it because they have to come for inspection. My prayer is for inspection.
We don't know. We don't know what will happen on 15/7. We will see.
Yeah.
Tomorrow.
Item 21.
Lordship had directed to Lordship, direction was to the collector to inquire regarding encroachment and take action if there is encroachment. An inquiry has been conducted and 9 encroachments have already been found out. And now we are taking action for eviction and settlement. Some time may be given so that we can do it within time.
Let's see the order.
Lordship can look at this order. They've quoted it, I think, so they have not filed that application. Order. Now, page 3, they have quoted the order in the body of the contempt petition. Now, paragraph 4, that page, it has been further argued that the collector Kotak be directed to make an inquiry into illegal allotment of Gochar land of village under such an, and after inquiry, such illegal allotment shall be cancelled. Mr. Mahanti, learned additional government advocate, appearing for the office 129,
Yes.
submitted that the government doesn't have any inhibition to inquire into the allegation.
So you have already violated the order. So what do you want?
No, we have made an inquiry, Lords. We have found that the allegation encroachments, I've got the instruction. Now we have to cancel it, take action as per the OPLE Act. This is the encroachment we have found out, Lords. Inquiry has been completed. Now we
We
will
need to complete the inquiry.
inquiry was completed on only 5/7/2024.
Right, so what is your explanation? The order was passed on 7/7.
Yes,
So what did you do thereafter? In the present contempt application, the petitioner has alleged disobedience of an order passed by this court dated 7/7/2023 in WP number 20917 of 2023. Stop. That a detailed so-called reply be filed on behalf of the contender, stating disclosing the steps taken after a receipt of the said order dated 7/7/2023 by them in the direction of a removal them regarding compliance of the said order. Full stop. Next, learned AGA has submitted that an inquiry has recently been conducted on 5/7/2023, and the allegation made
No,
in the present-
24, Lordship said 24.
24, and the allegation made in the writ petition of encroachment has been found to be correct.
Yes.
So Softly has also submitted that the steps are being taken for removal of encroachment under the OPLE Act. Full form. So stop. Next, we are not prima facie, we are not satisfied with the submission advanced on behalf of the contemners, as we do not find any justification for an inquiry, nearly 1 year inquiry into the alleged encroachment. Inquiry into the alleged encroachment nearly 1 year after the order of this court dated 7/7/2023 was passed. So stop. List this matter on 4 weeks. For how much time will you take for that OPLE?
Yes, within 4 weeks we'll complete
Or
it.
4 weeks.
OPLE proceeding, don't you have to issue notice and
Yes,
hear
because
the-
Gochar land, G form will be issued, 15 days time will be granted to eviction because settlement cannot be done because it's on the Gochar land. Yes, that is why eviction will be easier. Item 22. It's in item number 22, Lordship Director will file that affidavit, but that affidavit is almost ready. I will file in course of the day. So Lordship may take it out tomorrow, day after, and serve a copy on my.
Forget affidavit, whether you have complied that or.
Yes, my lords. Here there was a direction. If your lordship kindly come to the order of this honorable court, my lords.
Yes.
The petitioner had approached the learned tribunal, administrative tribunal for regulation of his case, my lords. And OA was dismissed, my lords. That was challenged before this honorable court. And this honorable court, my lords, were not, my lords, inclined to entertain that, my lords, writ application, said that the order of the tribunal is, my lords, correct. And only on the basis of the request made by the council that the petitioner has worked in a promotional post and he is entitled to get some differential salary for that in that post, he should be granted that. This honorable observed that if his work, it should be granted. Now we have found out that he was initially appointed as a class 4 employee. Thereafter, he was promoted to a class 3 post. He worked there for 4 to 5 years. Thereafter, that base post was abolished. However, he was allowed to continue in that aforesaid post to the same salary of class 3 minutes. And he, while working, he was kept in charge of another base level post of photographer, who is also a class 3 post for 5 years, from 2011 to 2016. And he continued there 5 years. Thereafter, he retired from service. But because he was working in that post, class 3 post, he was paid the salary of a class 3 post, but he was not paid the salary of that photographer because his salary was more than that post. That is our explanation, because he has already received the promotional post salary more than that. He is not entitled to any differential salary. That is our counter.
My lord, actually, not on the basis of the request made by the council for the petitioner, on the basis of
No,
the,
that is not the question.
yes,
We are not deciding here your rights.
yes,
We are deciding their conduct
yes.
regarding compliance of yours. So, or non-compliance.
My lord, my submission before your lordship is that keeping in view a judgment of this honorable court, the earlier case was disposed of, directing them to pay me the salary for the promotional post
We
for the
will
period.
go into that aspect, but first of all, we will see what order was passed.
Yes,
and
yes.
which order has been violated, which
Yes,
part has
yes.
been violated.
Page 10, page 10.
Page 10.
Yes. page 10, my lord, last para, 3 to 4 lines before. Your lordship, last para, lordship got it.
Yes.
However, learned counsel for the petitioner further submits that the petitioner was also not granted the salary for the promotional post for the period, although he worked in that post for some time in officiating capacity. Hence, the petitioner is entitled to the salary of the post for the period he worked in the officiating capacity. In this regard, he has placed reliance upon a decision of this honorable court in case of so and so, and submits that if an employee is ordered to work in a higher post, though temporarily, he is entitled to the salary attached to the higher post. We have considered that aspect of the matter, and in view of the decision referred to above, it is directed that the petitioner shall be paid the differential salary of the promotional post for the period he worked.
So they are saying that that has been paid.
My lord, that
And there is no, all right.
Yes.
Now tell us,
Yes.
where have you said that you are entitled for this much of differential salary, which has not been?
That I have not stated.
Then contempt.
My
will
lord,
not-
may I submit? Let them serve a copy.
No. Contempt, they will not do something to make out
That
contempt.
is, my lord, that is
No.
fine. That is true. My lord, they cannot go beyond the order. That is true. But my submission before your lordship is that I have not received the differential salary which I am entitled to.
So what you are
Right now,
entitled?
my lord, this exact salary.
Exact salary, then the contempt will not lie.
They,
You can have,
I'll file an affidavit.
they are saying that the salary in that post is lower than the salary which you have got. On the other hand, if you want to insist that you want to be paid the salary of that post, you may have to refund some of the salary.
That is true, but I have talked to the client. He, according to him, he is entitled to get.
Then he will file another, but they have complained.
not
as
in
per
the contempt proceeding.
No, not in the contempt proceeding. That is fine.
The-
Your lordship, may I pray, your lordship may kindly grant me the leave so that
The petitioner has alleged disobedience of an order of this court dated 7/11/2019, passed in WPC number 8484 of 2017. So, in the said writ petition, an order passed by the State Administrative Tribunal Cuttack bench was challenged by the petitioner. First off, this court, while this court upheld the judgment of the tribunal, whereby the prayer for regularization of the service of the petitioner in the higher post was rejected. First off, the court, however, while dismissing the disposal of the writ petition, made following observation, dash. From however true, we have considered two paragraphs. We have considered two paragraphs. One begins with however, and second with we have considered. These are last. Stop. Learned counsel appearing on behalf of the petitioner has submitted that no differential salary of promotional post has been paid, despite this court's direction. Stop. Learned AGA representing the contemptors has submitted that no amount of differential salary has been found payable to the petitioner based on the calculation arrived at by the officials. As the amount which the petitioner received is more than the amount which he was entitled to against the promotional post. And therefore, there is no differential salary payable to him. So stop. Next. Be that as it may, comma, it is pertinent to note that the petitioner has not specifically stated as to what is the differential salary which he is entitled to receive for having worked against a promotional post. Stop. In the facts and circumstances, we are not inclined to proceed further in the present contempt matter. Stop. The contempt proceeding stands disposed of accordingly. Stop. We, however, make it clear that if any decision has been that the petitioner shall be at liberty to raise his grievance against unpaid differential salary, comma, if that persists, comma, by approaching appropriate forum / court in accordance with law.
Oblige.
Item number 23. So I'm this matter, I've got instruction that pursuant to lordship direction, 12 encroachment cases were instituted. Out of them, order of eviction was passed. In 4 cases, some of the encroachers have preferred appeal, and some have also approached this Honorable Court in writ application where an order of status quo has been granted. Now the entire process has been now fixed to 12th for their eviction because order of eviction has been passed. Now they have to evicted by force, and date is fixed to 12/7. Your lordship may call it after 12/7 so that I can appraise the
what is the
lordship about
order?
the present status.
What is the order?
Your lordship, can you look at this order? Page 11. Page 11. The petitioner's representation under Annex 3 shall be examined by the Tahsildar Athagod, OP number 2, after notice to the petitioners and the encroachers named in Annex 3 and giving them an hearing. A reasoned order shall be passed thereon, not later than 1st June 20, and order be communicated to the parties within a week
The order
thereafter.
has been complied with. Order has been complied with. They have passed the order.
It has not been communicated to petitioners.
Communicated.
Will communicate.
And also, the petitioners have also not been noticed when the process of the eviction started or notice of encroachment case was issued.
12 persons were found to be in possession in their presence. And thereafter, notice was issued to them, and order of eviction has also been passed by the authorities.
An order of eviction.
Let it come after 12th.
By 12. The order has been passed. The petitioner had alleged in WPC bracketed PIL number 4. WPC bracketed PIL number 8314 of 2023, alleging unauthorized encroachment over public land. The said writ petition came to be disposed of by this court on 27/3/2023. Which reads thus. What order? Stop. We have been informed by learned AGA that after notice to the encroachers in accordance with the provisions under OPLE Act.
Yes, sir.
Orders have been passed for their removal. and steps are being taken to evict them. So, next, learned counsel appearing on behalf of the petitioner has, however, alleged that no notice was given to the petitioners, nor the order has been communicated to him. So, next, since the order has been substantially complied with, in as much as a reasoned order has been passed after giving, reasoned order has been passed by the authorities against the encroachers, as stated by the learned AGA, we do not consider it to be a case of deliberate disobedience of this court's order. The contempt proceeding is dropped. The learned AGA is, however, requested to supply copy of the order passed by the who has brought Tahsildar.
Tahsildar Adgad Miras.
Tahsildar Adgad to learn counsel for the petitioner by tomorrow. All right.
For orders item number 24.
Ordinance for delay, my lord. Earlier, retapel was dismissed without, on technical ground, it was dismissed. For which I have again filed this writ application and it has been delayed by 4 days. The medical certificate I have filed, delay we can't do.
How much delay?
4 months delay.
4 months.
What order are you challenging, Mr. Jaina?
Yes, sir.
What order have you challenged in the writ appeal?
In this writ application?
Yes.
In this writ application, I have challenged that the writ application which has been filed, that was not maintained in this writ application I filed because
The writ application which was filed was disposed of in 2013.
13
In 2023, you filed an IA for modification of that order. If it was not maintainable, then I think there was a prayer that the compensation should be paid only to one opposite party and not the other one. So how are you saying it is not maintainable?
Here I have not challenged that. I have not challenged that to whom it will be paid. I have challenged that.
This is the order which we are looking at.
Yes, my lord.
So the learned single judge has dismissed it on the ground of delay, and that will amount to review of the order.
Review, yeah.
Two grounds. See page.
Which is?
Page 37.
Page 37, yes, my lord.
Page 37.
Yes, my lord, in this case, the provisional of the record, it appears that the application for modification of the order, but that the interim order, that was not the final order. My fight, that was the final order. That was the interim order. In the interim order, the state was asked to pay to consider the.
So that was not the final order.
That was not the final.
Yeah.
Here, my lord, I'll tell you only one point. Whether the writ is maintainable or not on the instance of the entities. When the second appeal, the order was passed in my favor. In the second appeal, the order was passed in my favor. That the land belongs to me. And this honorable court passed an order that when NTPC, the other side, has filed an appeal, without filing an appeal, they filed a writ application for the honorable court that the land which we have already acquired, then we will not liable to pay, the state is liable to pay the compensation amount because they have taken the land from the state. But the court, this honorable court held that the foreign notification will be made by the state, notification under the Land Acquisition Act will be made by the state, and the compensation will be calculated and it will be paid to me. But instead of to me, they have done that to my brothers and sisters, the two other brothers. Because the two other brothers, they have already in their partition, family partition, that land belongs to me. That was in the second appeal, the finding was there. That's why I had tried to modification of the order. But that was interim order, and they have till yet they haven't
acquired the land under the provisions of the Land Action Act, nor paid the amount till date. And this is my home suit, because by that time on this honorable court held that the REIT application itself is not maintainable. That's why you dismiss the appeal because we cannot modify the order. Then in this REIT application, I have challenged that the REIT application filed by the NTPC is not maintainable. Was not maintainable. That is the only. If not, then the order will stand. The single judge order will stand. Then they have also till date they have not paid the amount.
Yes.
NTPC is to be noticed because the order was passed in favor of NTPC, who was the petitioner. Lordship may issue notice.
Could you please repeat?
Well,
Could you please repeat why do you say that the writ application is not maintainable?
maintainable because the right title interest in my favor has been declared. As the second appeal. And they have filed a REIT application where the with the because that is not the NTPC was not the party in the lower court.
Yes.
Party in the lower court. His remedy was authorized. REIT application, he cannot challenge that. The order of the second appeal.
That order has not been challenged.
That order has not been challenged.
So writ petition was not filing the was not filed challenging the order in past and second appeal.
The REIT application filing second appeal.
Where is the copy of the writ application? Is it attached? Oh yes, it is there.
The prayer is quoted in para 30, page 37.
No, the application is there. Oh, just scanning.
Second appeal.
Yes, yes.
And if the writ
Yes,
petition
that is
was
there.
not maintainable,
But
then his writ appeal is also not maintainable. For the reason that writ petition.
Yes, well, exactly, my lord. If the REIT appeal is not maintainable, REIT appeal is also maintainable.
Not for that reason, for the reason that that writ petition was entertained, might have been entertained under Article 227, not 226.
Yes.
Because an order passed by a court was challenged. It was
Then the
entertained, then where is
the court has been the single judge has passed an order that we are entitled to compensation. That is not disputed. But only the fact is the only small mistake was there that instead of in my favor, he has granted the compensation in favor of my brothers and myself.
And that is a separate cause of action because the impugned judgment reveals that the Honorable Court disposed of the writ petition on the basis of in terms of the order dated 19th February 2013.
Those are interim orders.
Those are interim
So
orders.
on basis of that, the writ petition has been disposed of.
Yes, my lord. But if he has got any grievance, so far as the payment of compensation is concerned between two brothers, controversy, then that is a separate cause. That is my responsibility.
You could have sought this clarification or sought modification. You could have filed a review application. Why? Your IE has been dismissed from the ground of this.
Same day. IE was dismissed and the writ application was disposed of.
Then, my lord, if the order of the single that I may given a liberty only that at the time of land acquisition proceeding, I will raise my grievance there.
That is always there.
With that liberty, the petition will.
Where is that? That order, final order.
This court, page, page 40, running page 40.
That apportionment,
Where is the order of this court?
page
Oh,
37,
this court order is paid 37.
36, 37.
37. 36, 37,
You have not page marked the brief.
36.
WPC 32131 of
No, no.
2011.
No.
Sorry, there. There. I have opened that actually. Order is at
Please come to page 39.
39.
Page 39 is what?
Para 4.
Para 4.
This is disposal of the writ petition.
yes.
This is the order of this one.
But this is in your favor.
Yes, that is my favor.
Then
My only that mistake was there. Kindly turn to page 37.
It's much.
The award is would be passed and compensation is would be determined shall be paid to the opposite party of
37, where is that?
Yes.
Before that.
3 months. Then my lord, kindly I draw your lordship's
Which
attention
part of 37?
to page 29.
Wait, wait.
Are go page tap on.
Which order dated 23/7/2013. So which paragraph do you want us to see?
That is it, para.
Paragraph 7.
Para 7.
The page कितनी?
Page
Final
36.
order.
36.
That is quoted in that order.
See, a writ petition was filed. Now, where is the order by which the writ petition was disposed of?
37.
Last
39. 39 last para 4.
There are
So this is the final order.
Yes, madam.
This is the final order, order number 16.
Order 4. Para 4.
Yes. Final order is order
Page
16.
39 para 4.
Yes. So how does paragraph 4 disturb you?
Only my grievance is that then I'll draw your lordship's attention to page 29. The order of the second appeal order, para 13. Page 29, para 13.
No. Where is that? It is said, it is made clear that in the event the matter is settled, the opposite parties 4 to 6 landowner shall not claim any benefit under the rehabilitation. That is there. Where is it that pay to 4 to 6?
4 to 6, kindly 6.
There is no specific direction that you paid to court.
Yes, sir, that's specific
So
direction.
even if they are not allowed to go for compensation, rehabilitation when they might have got, but this also the court has said no.
No, that I'm not.
Then what are you aggrieved by?
That is only that the further the demarcation the award age would be passed and compensation age would be determined shall be paid to the opposite party of 4 to 6 immediately.
Where is that?
after
Where
3
are
months.
you reading?
That is in page 37.
Page 37.
Yes, madam.
That is the previous order.
Yes, previous that
Oh.
that order was
23rd
not come
July.
in the final order.
In terms of that order, the writ petition was disposed.
Shall be demarcated who shall represent all the plaintiffs. Date
All
of demarcation shall be notified. Okay.
ମୁଁ କହୁଛନ୍ତି 2 ଜଣ ନେବେ.
ଜଣେ ପାଇଁ ନା ଦି ଜଣ ପାଇଁ, 3 ଜଣ।
So his grievance is that instead of 4 to 6, only his client is entitled to get.
My lord, the
Yeah, तो?
details page 18 में kindly be seen. Writ application page 18. The details order is there.
So where is this order? 23rd July.
23rd July,
Page 18.
page 18.
That was an interim order. Second appeal order will merge with the interim order and straight. Annexure 3.
Annexure 3, ma'am.
Page 20, there is a direction that opposite partner 4 to 6. Payment to be made to the opposite partner 4 to 6.
So we will have to issue notice
But
to
that is the
everyone.
finding.
So by the
Then-
interim order,
Yes, yes. Now, if
State
any
was
order
asked
is
to-
passed, then it will adversely affect the other two private opposite parties.
That's why I'm taking this
Notice.
proceeding this is.
My lord,
state has not challenged this order.
no, that,
Because you were directed to initiate.
no. There are two
acquisition.
options for the petitioner. They may raise this point during the land acquisition proceeding. That not the opposite partner 4 to 6, but I am alone entitled to get the
They
compensation.
will say.
Because
that
there is a
order of the
direction.
High Court.
That is a
No,
direction. So
Unless
if
it,
you
unless it is varied.
varied, so to vary it, your lordship is to notice the
That is
private.
what- that is
That
what-
is, otherwise should not be,
Issue notice.
because they will be prejudiced. Other two parties, they are.
Have you pleaded them, your brothers?
Your brothers are there.
Yes,
Yes, ma'am.
yes,
Issue notice.
yes, sir.
5
To
to
accept notice on
9.
behalf of opposite parties number
5 to 9. Respondent 5 to 9.
requisites 1 week. 8 weeks. Yes. Limitation? Both. Point of limitation.
What limitation appeal? IA as well as this appeals.
Item 45. Item 45, Lordship has fixed it to 2 p.m. The virus of 2013 Act is under challenge. May I pray, Lordship may take up this matter next week so that
Why?
the Advocate General will.
Let's say Advocate General is not there.
One accommodation only. Because the virus of 2000 Repeal Act, many people will.
Maybe. We cannot close the court.
Well, what, 2-3 days at least, 2 days accommodation.
So we don't know.
Only
It's
one.
very- Quite embarrassing for us.
Yes, but
Let us start.
only one
Let us start. Maybe Advocate General may not be required
that
because we may not find any illegality in the rule. And if we find, enough is enough. Let us start. Yes. Yes.
I had prepared a date of events for Lordship that I've given the last time also. Copy only given.
Yes, list of dates are there.
Various councils are there, all are under the impression that because of the Advocate General is not there, possibly the magistrate. That is what, anyway, but I'll start it. So here is a.
We cannot
That is exactly the.
close the court
One prayer, matlab, 1 day or two?
Not even
Well,
an hour, Mr. Yes, so which rule is on the chart?
Yes, Lord. It is in fact we have challenged the 2022 repeal rules as well as the amendment of 2013 is the subject matter of challenge. Just I'm showing your lordships certain dates. Then I can to bring to lordships notice what is the exactly the background. But the date chart I'm giving to lordship that I've given up to lordship last time. I think that is available in records.
One list of dates is there.
Case number is WPC 9791 of 2023.
9791.
9791. Sitakanta Mishra and others. Next copy.
First one. First one.
First one, yes. I think my Lord, Honorable Chief Justice first. Got it.
No, list of dates. List of dates is there, but
No, date chart along with note of submissions.
Not scanned. Whatever document they give, you should scan it. Not there in the record. There is the record. Please give a second copy.
Extra copies I have also. You also keep kindly.
No, but whatever document did, you have to scan that thing. And index. They are scanning, but not giving the index sometimes.
Let me start then. If my Lord can keep it to next week. 17/12/1993.
yes.
This Orissa Subordinate Education Method of Recruitment and Condition of Service Rules 1993 came into force, regulating the method of recruitment and condition of service of the persons appointed to the post of teachers and equivalent post in class 3 of the state civil service in the office subordinate to the Director of Secondary Education. This was the rule which was under Article 309, that is Annexure 1. 4/11/2003, in view of grim financial position of the state government, wherein it was not possible, that is the resolution, wherein it was not possible to make regular appointment, a resolution was issued by the School and Mass Education Department, laying down eligibility criteria and method of recruitment of qualified teacher in government old/new high schools on contractual basis against the vacant post of teachers in high school. That is Annexure 2 at page 49. Then on 21/5/2005, another resolution of similar nature dated 4/11/2003 was issued prescribing manner of recruitment of teachers in old and new high schools on contractual basis. That is at Annexure 3 at page 56. Then from 2006 to 2012, advertisements were issued from time to time for recruitment of teachers in government high school. That is Annexure 4, 5, and 6. Then 8/12/2008, the government issued resolution prescribing the manner for recruitment of teacher in government high schools. Then 25/7/2011, this is important. A regularization policy was framed for regularization of contract teacher, wherein it was decided that upon 6 years of continuous of satisfactory service, a contract teacher shall be regularized and be eligible for all service benefit as are admissible to regular employees under the state government. That is Annexure 8 at page 82. Then 17/10/2012, advertisement was issued for filling up 3,519 posts of trained graduate teacher and non-trained graduate teacher. That is Annexure 12 at page 162. Then next page. 3/6/2013, an advertisement was issued for filling up TGT posts in government high school. On 12/11/2013, the rule came into force. The Orissa Group C and Group D Contractual Appointment Rule 2013 came into force. That is Annexure 16 at page 184. 17/1/2014, Orissa Group B Contractual Appointment Rule 2013 came into force. That is Annexure 18. That is Group C and D. This is Group B. 27/10/2014, for the first time, an advertisement and resolution prescribing the method of recruitment and qualification was issued in terms of Orissa Group B Contractual Appointment Rule 2013 and Orissa Group C and Group D Contractual Appointment Rule 2013. This is the first advertisement. This was made on 27/10/2014 after the rule came into force. The 13 rule came into force. On 16/10/2022, 2013 rule was repealed by virtue of Orissa Group B, Group C and Group D post repeal and special provisions rule 2022. This was repealed. 13 rule was repealed. Then on 13/4/2023, a standard operating procedure was issued for regularization of service and fixation of pay in respect of secondary school teachers and the school and mass education department. In the SOP, the secondary teachers were categorized into three categories. In fact, in this REIT application, all these REIT application, this rule to 16/10/2022, I'll take your lordship to that rule, and the consequential standard operating procedure, which was also issued, which directly in connection with that repealing provision, that is the subject matter of challenge.
So you are challenging this 2020 repeal?
We have challenged the 2022 repeal.
22 repeal.
Yes. And also consequentially, the SOP of 22/6/2023, this has been challenged in all subsequent REIT application, but in the first REIT application, though it was an amendment petition was filed, but pending, but other cases that is challenged. Because we are arguing the cases composite nature, same order.
This challenge is on what ground?
But
Broad ground.
yes, challenge, I'm just submitting that the short note of submission like this. Right from 2003, there was a rule in 1993, but there is a provision of relaxation that rule. They have not resorted to the rule. In 2003, they made a policy that they will give appointment on contractual basis because of the financial condition of the state government. And the advertisement was, that resolution was passed in 2003. That resolution has to be kindly look, because that is the genesis of the, that is at page 49. Annexure 2. For 11/2023, this is the Government of Orissa School and Mass Education Department. The vacancy position of teachers in government high school, old and new, of the state is alarming, which has adversely affected the teaching in the school. The result of HSC examination is deteriorating year by year due to shortage of teaching staff. In view of the grim financial position of the state government, it is not possible to make regular appointment in vacant post, market, in the vacant post of teacher in the high school. In view of the gravity of the situation and after careful consideration, government have been pleased to engage qualified teacher on contract basis in different government high school, old and new, with the following terms and conditions. This is the number of posts. These are the number of posts, eligibility criteria. The eligibility criteria is more or less as per the rule. The requirement to engage a teacher, or that is in consonance to that rule. But appointment is on contractual basis. Then if you also will turn to next page, page 50, reservation, then selection. The direct selection is bottom of that page, page 50, reservation middle, ORB Act and reservation as prescribed by the government from time to time shall be followed. Then selection, emolument is a contractual emoluments. Then selection, the director secondary education would bring out an advertisement indicating the post to be filled up in each circle, that is PCM, CBZ and classical teacher. PCM means physics, chemistry, mathematics, chemistry, CBZ and classical teacher separately, and invite application circle-wise to be filled before the respective inspector of school residency certificate, and these are the conditions. Who are the committee shall constitute collector, principal, diet, senior most DI of school, district welfare, that is at page 51. Let's see that committee, the selection committee.
This is of 2003.
2003. Likewise, they made, thereafter they made the advertisement up to 2011. Now you also come to 2011. They decided to regularize the service. That is important. That you also kindly come to page 82. Page 82. This is the government policy.
Yes.
I am not taking to lordships of other advertisement. On the basis of this resolution, several advertisement has been made in the meantime. Then they decided, page 82, on 25/7/2011, regularization of service of teacher engaged in the high school on contractual basis. Let's get it.
Yes.
The state government, as part of austerity measure, adopted contractual mode of engagement of personnel with payment of fixed sum per month as consolidated remuneration. The government in school and mass education department decided to engage contract teacher in government high schools, creating such post on abolition of the vacant regular scale bearing post of a category by resolution number so and so dated 21 May 2003. Accordingly, contract teachers were engaged in phase manner on abolition of equal number of regular scale bearing vacant posts. The government in school and mass education department at a later stage framed the career advancement policy by resolution number so and so dated 8 December 2008 in keeping with the later dated 3rd August 2004, dated 31st December 2004 and 13th October 2006 of Finance Department. In pursuance of the career advancement policy, the contract teachers shall be regularized with regular scale of pay attached to their post after completion of 6 years of continuous and satisfactory service, whereby they shall be eligible for all service benefit as are admissible to regular employee under the state government with effect on the date of such regularization.
So this resolution is applicable to such teachers only who were working as on 25/7/2011.
Right.
All right.
Yes.
So even if after completion of their services of 6 years they were to be regularized, a person appointed on 24/7/2011 could be regularized after 6 years.
After 6 years.
But not beyond 6 years.
But not beyond 6 years. That's it. That is no dispute.
A person appointed after 25/7/2011 cannot claim any regularization under this resolution. They can.
If a person has been appointed prior to 2011,
post 25/7/2011,
they have been governed under this resolution and their service have been regularized on completion of 6 years of service.
Right.
Suppose a person has been appointed in 2004 or 2005, they completed 6 years of service on contractual basis in 2010 or 2011. Their service have been regularized from that date. That is, they have done it.
From that date?
Yes, sir. So again, I'm reading. Last 4 lines. The contract teachers shall be regularized with regular scale of pay attached to their post after completion of...
Which paragraph?
I'm reading at page 82, paragraph 2.
Yes.
I'm reading again, sir.
Yes.
I'm reading the first paragraph also. What is the purpose and object? The state government as an austerity measure adopted contractual mode of engagement of personnel with payment of fixed sum per month as consolidated remuneration. The government in school and mass education department decided to engage contract teacher in government high school, creating such post on abolition of regular scale bearing post of a category by resolution dated 21 May 2003, which just now I read to you. 21 May.
But do you want to say that because of this resolution, someone who was appointed in 2003 will have to be treated in regular establishment with effect from 2009?
They have done it. On completion of 6 years, they have done it. By virtue of this resolution. There is no dispute over that. On 25/7/2011, when this resolution came into force, they have regularized the service on completion of 6 years from the date of their initial appointment, engagement as contractual basis.
Date of the regulation.
From the date, but they are given all benefits of a regular employee on completion of 6 years. That is the only what they have done.
Mr. Rautre, one doubt.
Yes,
this resolution which is referred to in paragraph 1, what is that?
That I read just now. So that is ongoing.
When did you read it?
Yes,
don't have it?
that is, I think, that is not there.
That's not
That
there.
is not available with me. That is.
That relates to abolition
but the-
or creation.
Yes, but the resolution letter 411/2003 on the basis of which the selections were made, that is at page 14.
That is the resolution which you have referred to?
No,
No, that is a, I'm sorry, Milord, that annexure 2 is a resolution dated 411/2003, which just now I placed. But this is a resolution dated 21 May 2003, subsequent to that.
So does that relate to creation or abolition?
That is
Because
both.
here, the two resolutions which you referred to is for dearth of teachers, so not possible to make regular appointments.
Right.
So here it starts with austerity measures.
Here also, it page 49 also see, in view of the grim financial position.
All right, so that relates to that.
That is the purpose.
But what is that 21st May? Does it have any bearing on this?
I'm not sure. I don't think that's.
All right, we'll see.
Right. So just I'm reading, the government in school and mass education department at the largest.
It gives an impression that the vacant regular scale was abolished.
Yes.
By this.
But yes, what they have done in lieu of abolition of the.
That we can understand. But
Yes.
this resolution 21/5/2003
Yes.
refers to abolition of the regular
Yes.
posts.
That I can't, sorry, I couldn't, because that resolution is not with me.
All right.
Right.
Yes. Then
Lord, just I'm reading paragraph 3. Government, after careful consideration, have been pleased to decide that regularization of service of contract teacher in government high schools shall be considered only on fulfillment of the following terms and conditions. The conditions are there at page 84. Page 84. Then you also kindly come to page 86, the regularization part. After this 2011, how they have done it. On 6/3/2014, in pursuance of the government in school and mass education department resolution dated 25/7/2011, just now I read, and government memo dated 28/2/2014, as communicated by memo number so-and-so dated 1/3/2014 of the Director of Secondary Education, Odisha, and on the recommendation of the screening committee in its meeting held on 15/7/2013, the service of following contract teacher are hereby regularized and they are appointed as assistant teachers in their respective high school on completion of 6 years of continuous of satisfactory service in the scale of a regular scale, 9,300 to 34,800, with a grade pay of so-and-so for the TGT, PCA, post are usually with DA and other allowances as due and admissible to him in a sanctioned post as per the government from time to time with effect from the date mentioned against each other. Sitakanta Mishra is petitioner number 1 at serial number 7, Anchalika High School, TGT. He got the appointment on 31/10/2007 and at completion of 6 years, that is on 31.
But I want to see one decision of the state government where was given regular appointment with effect from 2009 because he or 10 because
Completed
he had
10,
completed
6 years old. That is annexure 9.
This is different. This annexure 9 is different.
That is the order they have regularized the service, taking into consideration.
You're
6.
right.
Yes, sir.
You're right.
That you also say what is yes.
What we gather from the notification which you were referring to.
Sir.
See, regularization cannot be retrospective from date when a person completes 6 years. On the date when the policy of regularization comes, all such persons who have completed 6 years from that date, they will stand regularized. This may be one interpretation of it.
That's right.
And all persons who complete 6 years thereafter,
yes,
they shall be regularized. So this notification with effect from the date when they complete 6 years.
6 years.
So this notification refers to that. This is after 70. What is the date of that resolution?
25/7/2011.
25/7/2011.
Right.
Oh, no, you are referring to 13. 27,
25/7/2011. Yes.
2011.
Yes.
So this is after 2011. All these
Yes.
these
Yes, sir.
orders have been passed when a person completes 6 years after 2011.
Yes. Yes. Yes.
So can there be a circumstance where the service of a person can be treated to be regular prior to 25/7/2011? No. Yes. It cannot happen.
But they have done in some cases. Those
They
persons
might
those are
have
appointed
done,
in
but
2000.
that cannot be.
Have they done by themselves or pursuant to
Yeah,
order of the
after this-
tribunal or
only after
something?
this resolution was passed.
That
To that effect, I'm clarifying one point only. My learned senior has shown my lords that 2011 resolution. Prior to that, there was another resolution made in the year 2008, wherein it was decided to regularize the persons who were appointed prior to 2008. On completion of 6 years, they will be regularized. The lordship can find it from my counter.
all right, we'll see later.
Yes.
We'll see later.
Yes.
Let him complete.
And on the basis of this resolution, my specific case is that because we are appointed in 2006 and we completed in 2012, on the thereafter means after 25/7/2011, they have regularized our service on the date we completed 6 years of service. That they have done it. That is what I was showing to your lordship. That is Annex 9 at page 86. That is the order. Now, now, so far as
Mr. Rautre, sorry for interrupting. I think that date is a type. There's a typographical error in that page 82
82.
because the resolution which is referred to 10562
That's
is actually resolution of 2005.
Maybe.
Please check it later
I'll check it.
because I found.
Because 2005 also I've given that one.
Yes, yes. The
That's
number tallies.
21/5/2005.
Yes, yes.
That number tallies with that. So your lordship is saying that 21/5/2003 may be a mistake.
Maybe. So that we can check up later.
I'll
All
check.
right.
I'll check up. Then your lordship kindly come the rule they have brought it in 2013 rule at page 184. 184.
Yes.
This rule, for the first time, they have made this rule under Article 309. In exercise the power of control by 309, this 2013 rule came into force. Your lordship kindly come this rule 5. Your kindly come to rule 5.
Yes.
Recruitment procedure. Recruitment to the post shall be made on the basis of the provision of the relevant recruitment rule or executive instruction as the case may be in force. Notwithstanding anything contained in the relevant recruitment rule or executive instruction as the case may be in force, all appointment made pursuant to sub-rule 1 shall, from the date of commencement of the rule, be on contract basis. Status of the vacant post. For the purpose of contractual appointment made under sub-rule 2 of Rule 5, all vacancies existing on the date of commencement of these rules, as well as the future vacancies, shall be deemed to have been converted to contractual post from the date of commencement of these rules. Am I clear? Now you also come to Rule 9 after 6 years. That is at page 187. Condition of service of contractual employees appointed under sub-rule 2 of Rule 5. As your lordship rightly said, now they have brought this rule in 2013. Those persons will be appointed in terms of Rule 5 of 2013 rule. They also, on completion of 6 years, they will be deemed to have been regularized. That is the rule they have brought. Now, Rule 9, you also look to that. The tenure of contractual appointments. Part 3, condition of service. Rule 9(1). Tenure of contractual appointments. Persons appointed under such rule, Rule 2 of Rule 5, against the contractual post shall continue on contractual basis for a period of 6 years. The period of 6 years shall be counted from the date of their contractual appointment under Rule 5. Then, this is the rule. That means they, then let's see that deeming provision, they have made a deeming provision. Page 188. Rule 10, regular appointments. On the date of satisfactory completion of 6 years of contractual service, under sub-rule 1 of Rule 8, they shall be deemed to have been regularly appointed. I think let's get it. So this is the rule for the first time. They brought it 2013. Group C, D, one rule. The other one is Group B. The teachers, graduate teacher, that is Group B, same provision. Now your Lordship may kindly come to the repeal provision, which is the subject matter challenge. Page 209. Page 209. This is dated 16th October 2022.
Yes.
These rules may be called Odisha Group B, Group C, Group D, Post Repeal and Special Provision Rule 2022. Contractual rule means the Odisha Group B Post, Group D under 2013 rule, and the Group C, Group D Post under Contractual Appointment Rule 2013. Now, Your Lordship, come to page 210. As Your Lordship, this is exactly they have said at para 4, special provision. Repeal 3, save as otherwise provided in Rule 4, the Odisha Group B Post of Contractual Appointment Rule 2013 and Odisha Group C and Group D Post Contractual Appointment Rule 2013 are hereby repealed. Then 4, special provision. The initial appointees appointed under the contractual rule. Contractual rule has been defined, that means 2013 rule, not the other one, those who have been already regularized. Now in position shall be deemed to have been appointed against the post on regular basis as on the date of commencement of these rules. Then 2, on such regular appointment under sub-rule 1, the pay of such employee shall be fixed by way of granting notional increment considering the date of their contractual appointment. Pause for a moment, sir. This, they decided when they made the repeal provisions, the notional increment considering the date of their actual appointment pursuant to the 2013 rule. Suppose somebody has been appointed in 2015 or 2014. Then from that date, the period of service will be counted for the purpose of notional benefit for increments. For the purpose of increment, that means they have taken into consideration the past period of service of 6 years. So far as the person, those who are appointed on contractual basis under 2013 rule. Now, then 4, the employees whose service have so regularized shall be allowed service benefit like promotion, etc. in the cadre of notional, in the cadre on notional basis to which they would have been entitled as per the rule had they been recruited on regular basis. This is now the people are taking your lordships to the next SOP. What they have done, so far the person, those who are appointed in 2005 and their service has been regularized in 2011 after 6 years, or the person, those who have been appointed in 2010, their service has been regularized in 2016. Now, so far those persons are concerned, even if their service has been regularized pursuant to that resolution of 2011, but that period of 6 years was not considered at all. Whereas, by virtue of this repeal provision, only those persons, those who are recruited under 2013 rule, again the self-serve post, and they are much junior to us, they were allowed to get the benefit of that 6 years. As a result of which, once notional benefit is granted, they will not only be financially gainer, but also they will be placed senior than all these persons. And what they have done it in that SOP. That is consequential to this.
This doesn't help you. The initial appointee is appointed under the contractual rules.
The contractual rule is 13 rule, not to the, also contractual rule has been defined.
Now in position shall be deemed to have been appointed against the post on regular basis on the date of commencement of these rules.
These rules. That means, so far these rules means the 13 rule.
Yes.
Those persons, they now take the advantage of this special provision, repealing provision, as a result of which the person, those who have appointed 10 years before, now they have been deprived of getting all these benefits. And that is very clear from SOP also, and also the page 211 .c. Rule 4.5, that is also seniority. Page 211. 211. That repeal provision. On commencement of these rules, the employees shall be assigned seniority in the cadre to which they would have been entitled as per the rule, as per rules, had they been recruited on a regular basis. So the person, those who have been appointed in 2010, they are completed 6 years of 2016. They after this resolution was passed, now these persons, those who have taken the benefit of 13 rule, but now that is repeat, they will only get the benefit of that 6 years, and that they will be treated to be senior for all time to come. You will also look to that SOP. They have made the SOP subsequently. Of course, that has been challenged in other cases, and my other friends have also challenged that. Yes, that is at page. That government has enclosed that one also. I have also enclosed in the rejoinder.
Filed by
The the additional government advocate has filed an affidavit on 4/11/2023. In that affidavit, they have enclosed this.
Page running by 287.
Let's say look to running page 287. This is directly in connection to that repealing provision. They have made it immediately thereafter.
87.
Yes, page 286. Start from page 286. Running page 286.
Yes.
Standard of this is by the Government of Orissa School and Mass Education Department to the Director of Secondary Education, all district education officer. Subject is standard operating procedure on fixation of pay in respect of the employees regularized under notification dated 13/4/2023 of the School and Mass Education Department. That means after this repeat. Sir, in continuation of the department notification dated 13/4/2023, I am directed to enclose herewith the standard operating procedure SOP in respect of the employees regularized, to be regularized as per the notification dated 13/4/2023 stated above for fixation of pay of such employees. We'll also look to the next page.
13/4/23 comment these are
Page 287. Let's get it. Page 287.
After 286, we have 289.
287. Next page is 287. That is their additional affidavit there.
continuation.
But then one affidavit has been filed by the additional government advocate on behalf of the state. That is on 4/11/2023. You will also be look to page 11 of that affidavit because that is not running page. I am taxing your lordships. That is the final affidavit filed by the state. That is, if you also will see that will give a picture of the how they have done it.
Released a supplementary affidavit received and kept in record.
That is in the note, office note, supplementary affidavit received and kept on record. That is in the note in the list appended to the, that is there.
So that SOP as per the index is 286 to 291. 286 to 291.
Yes.
Yes, 291.
Just check your brief if after 286, 2 pages are there or missing.
287.
287, 280.
What are they? Are they those communication memos?
No, that is the part of the SOP.
Part of the SOP.
The main SOP, where categorization has been made.
It is not there in the brief.
Madam, may I request you with well, I try to get a copy of your lordship's parallel copy so that it will be because additional affidavit and other thing has been filed so that I can refer it.
Yeah.
Yes, madam. I'm just reading that. Before that, your lordship kindly have a glance to this 13/4/2023, which has been referred to in the SOP. That is towards the last page of the brief. If you also can see that, that is the last affidavit which was filed by the state. 4/11/2023. Well, really, I was under the bona fide impression that state Advocate General is absent, therefore.
That is not absent.
Not if
That's, you understand that is,
Mr. Patnaik is there.
yes, yes, he's in charge. Regular service period, public regularization of teacher recruited before and after the notification of Odisha Group B post contractual appointments rule 2013. Wide notification dated 17/1/2014 of GA and PG department vis-a-vis Odisha Group B, C and Group D post repeal and special provision rule 2022. Wide GA and PG department notification dated 16/10/2022 as under consideration of the government. Now, therefore, government is pleased to consider the regular service period, public regularization of such teachers joining on contractual mode, public initial appointees as given below. 1. The regularization of those teachers, initially appointees, appointed in accordance with the Odisha Group B post, contractual appointment rule 2013, and J and PG department will be considered as per the Odisha Group B, Group C, Group D post repeal and special provision rule 2022. Those persons, those who have been appointed after 2013, rule came into force in terms of that rule. Then 2, the regular service period of the teachers who have been appointed contractually prior to the notification of Odisha Group B post contractual appointment rule 2013 and have also completed 6 years of contractual service prior to the notification of the said 2013 rule will be counted on completion of 6 years of contractual service, and their seniority will be maintained as per the position in the merit list in the year of recruitment in accordance with the department resolution dated 8/12/2008 and 25/7/2011. Am I clear?
Yes.
Then 3, the regular service period of teachers who joined contractually prior to Odisha Group B post contractual appointment rule 2013 and have not completed 6 years of service prior to the notification of the said rule will consider as per the department resolution dated 25/7/2011. However, irrespective of their date of regularization, they will be allowed 1, seniority as per the merit list of their year of recruitment and will continue to be senior to teachers recruited in subsequent batches year of recruitment. Then 2, notional pay not less than teacher recruited as per Odisha Group B rule 2013 department for the regularization of the contract teacher mentioned in paragraph 1 above, corresponding supplementary post in different category observing rule are being created. So far as 1 is concerned, however, respective of their date of regulation, they will be allowed one seniority. Also mark it, I'll show that how they have done it. Seniority as per the merit list in their year of recruitment. Suppose somebody has been recruited in the year 2008, same year of recruitment, that will be decided among themselves. That's all. and will continue to be senior to the teachers recruited in subsequent batches. This has not been done. If you also will see the SOP. SOP is thus next page. You also look to that SOP. That is at page 15.
Page 13
Starts from page 13, notification, but the real SOP contents is at page 15. Now they have made it category A, B, and C, capital A, B, and C. I'm just reading it very slowly. After commencement of Odisha Group B, C, and Group D post repeal and special provision rule 2022, issued by notification dated 16/10/2022 of GA and PG department, which came into force from 17/10/2022, Government in School and Mass Education Department, Odisha, has implemented the said rule in respect of government secondary teachers under their administrative control by notification dated 13/4/2023. Now, after careful consideration, the following modalities are defined for smooth implementation of the notification dated 13/4/2023. A, capital A. For these teachers, initial appointees within bracket join in accordance with the Odisha Group B post contractual appointment rule 2013 and Odisha Group C and Group D post contractual appointment rule 2013, along with this department resolution dated 27/10/2014, 1, Roman 1, the contract/initial appointees teacher shall be allowed fixation of their pay as on 17/10/2022, calculated notionally from the date of their joining by way of granting increments on completion of each year of service under normal circumstances. This is
the electric clarifies.
then 2. Fixation of pay in the revised pay structure shall be made by the head of the office, competent authority in the form at annexure A. Then B, they have categorized A, so far as person who has been recruited in 2013, they will get all benefit from the initial date of their joining on contract basis. Notional benefit they will get they will get also increments. Then B, for those teachers who joined contractually prior to the commencement of Odisha Group B post, contractual appointment rule 2013, and Odisha Group C and Group D post contractual appointment rule 13, and have not completed 6 years of service prior to the date of first appointment of contract/initial appointees teachers made as per this department resolution dated 27/10/2014. That means those persons, those who have been appointed prior to 2013, but they have not completed 6 years by 27/10/2014. This 27/10/2014 is important. Why? Because first time they gave appointment to the contractual appointees of 2013 under 2013 on that date. First advertisement. So 1, the date of regularization of service of such teachers will be revised antedated to 4/4/2016. Even if a person has been appointed irrespective of the date appointment, that will be antedated to 4/4/2016. The date of earliest joining of contractual initial appointee teachers as per the department resolution dated 27/10/2014. 2, seniority of such teachers shall be as per the merit list in their year of recruitment and will continue to be senior to the teachers recruited in subsequent batches year of recruitment. 3, they shall be allowed for fixation of their pay as on 17/10/2022 by of granting notional increment from the revised date of their regulation, that is 4/4/2016. Actual salary already drawn to the teachers will be adjusted against their revised entitlements. Then 4, fixation of pay in the revised pay structure shall be made by the heads of the office also. Then so far the C is concerned, we are concerned with C. We are coming under category C. You also look to category C. Or that is at page 16. For those contractual, let's get it at C.
Yes.
For those contractual initially appointees teacher who join in the service prior to the commencement of Odisha Group B post contractual appointment rule 2013 and Odisha Group C and Group D post contractual appointment rule 2013, and the date of regularization of the service falls prior to the first appointment of the contractual initial appointed teacher made as per this department resolution dated 27/10/2014. 1, how they will be treated. Service of such teacher shall be counted on completion of 6 years of contractual service, and their seniority will be maintained as per their position in the merit list in the year of recruitment. Am I clear? So our service should be counted on completion of 6 years, whereas those persons that will be counted on the date of entry into service contractual appointment. Then second is the position in the merit, the seniority list, where it will maintain as per the position in the merit list in the year of recruitment. Suppose I got the appointment in 2006. See, in 2006, whatever merit position I had, that will be fixed. Not that in comparison to those persons, because that 6 year we are not getting. Notional benefit we are not getting. But they have, and the C2, since the
What was the method of your entry?
Method, the procedure they have adopted, they have already provided. Same procedures. I have specifically said same procedure as provided under Rule 2013. Contractual. And also same contractual. Nomenclature is same. Remuneration is same. So that is why your Lordship, on the date of the first hearing, your Lordship asked certain question. Of course, the Advocate General is not there. Advocate General wanted to give some reply to that after consultation with the department. Your Lordship, give some them time, at least let them. I also be prepared with all rules and compilation. I'll give to your Lordship, so that should be convenient to your Lordship also to refer to those.
So we will continue hearing.
Yes,
Hear it
yes,
tomorrow again. Because otherwise, we have a tendency to this thing. Forget.
Tomorrow,
Monday.
Monday.
No. Then again, if required, we'll do it on Monday. We'll do it on day-to-day basis. All such matters, because see, so many cases
Yes,
have been
yes.
fixed at 2 p.m.
Yes, my
So
two.
every day we
No, but I understand. My problem is tomorrow another matter is also fixed at 2 p.m. That
here,
is,
no?
yes,
In
no,
this case, in this
no,
court.
yes, before my.
We will see, because the hearing in this case has started.
Yes.
So this will continue. Tomorrow we'll see what happens. And it is not that only one case can be fixed at 2 p.m.
No, that because
Required
yes,
more than a case can.
What is that matter?
that your Lordship was hearing that 2019 amendment Odisha Elementary Education.
Another matter of mine also fixed. That gate matters. There is a batch of cases have been
And
also tomorrow fixed.
That
Yes, that gate, yes.
3 matters.
That is also fixed tomorrow. So you'll also better fix it Monday. Take Mr. Kuntia
No.
at least at the last chance.
We'll take up the matter tomorrow.
Yes. Tomorrow.
Tomorrow. So,
I'll prepare.
what is your see? The only ground which he is taking is violation of Article 14.
Well,
This is the only ground, Mr.
sir.
Yes, ma'am. Yes,
That
yes.
is the only.
Yes.
What is your response on that?
Well, if your Lordship will see their prayer, what is their prayer? Prayer to declare the repeal rule as ultra virus. If your Lordship will declare that rule ultra virus, they will not get anything.
We will not declare any rule ultra virus in abstract. Before declaring, if we have to declare that ultra virus, we will have to consider the background in which this dispute arose, and
Yes,
and therefore it is not only that he is seeking that declare this act ultra virus, he will declare ultra virus and the petition is disposed of. This. We will have to address the
yes, ma'am.
controversy
The
and
controversy
the
and
reason, and then the fallout, everything.
and how they cannot claim parity with 2013. That I have to address, my lords.
That is what you are required to address.
Yes, that I have to address.
And Mr. Rautray, would you further advance any
Yes,
argument on this point?
I'll try to further advance. Yes.
This is the only thing.
Yes. Or take a slightly I can give. But
So you can.
this is
do
a
that-
more and this is a
You
substance.
can do that in reply,
Yes, I can do that in the reply.
and you just give us the bunch of
Yes, I'll
resolutions
and
tomorrow,
circulars and all the
right from, so that it may be easier for us to.
yes, madam. From 2003 till 2023, I'll a compilation of all the circulars and rules.
Ah.
I'll give it.
Give us, and then this is the only thing, and it's very small thing. If he succeeds, it's all right. If he fails, then also. Though it's Kuntiya Land Council, Land AGA representing the state of representing the state of Odisha has sought adjournment. Comma, we considered it fit and proper to hear Land Senior Counsel appearing on behalf of the petitioner. Full stop. We have heard him at length. Full stop. Does this matter tomorrow to be taken up at 2 p.m. for Mr. Kutia to reply?
Lordships, may I please? Lordships, on 21 of the tech writ petition, my lords. I'm led by Senior Advocate Pitambar Acharya. Will address the court in some other.
So let him address.
Grateful, man.
I have another matter with Lord's kind permission, item 50. I am the respondent.
50.
50. Can you also call it next week sometime so that because there is a judgment on, I have to find out that judgment.
All right, ask someone to be here when
Yes,
the matter is called.
No, he's there. He's the other side there. He's there.
Next week. Next week.
Next week.
For orders item 25.
Look, there's a nominal delay of 18 days in filing of the writ appeal.
We got the other side.
You're there for the respondent?
I am for the opposite.
So 18 days.
My lord, 18 days if taken from the date of the order, but by the time we received the notice from the registry, it's well within time.
No, were you not
My lord,
not
our
heard?
counsel was present, so there is a delay of 18 days technically speaking.
You are not Mr. Panda.
I am behalf of my.
What is your name?
Tapas Chakravarti.
Sorry?
Tapas Chakravarti.
Well, the issue is very short, my lords.
No, we first have to condone the delay.
My lords. IA number 6119.
Just one. Hold on.
2023.
This IA has been filed for condoning the delay of 18 days in filing this writ appeal. Heard Miss
Mamta.
Heard Miss Mamta Tripathi, learned counsel for the appellant slash petitioner, and Mr. Tapas Chakravarti. Mr. Tapas Chakravarti appearing on behalf of Mr. Niranjan Panda, learned counsel for the respondent. Sole respondent or how many?
No, sole respondent. Sole respondent.
No. Respondent number 1, contesting respondent.
Yes, ma'am.
Respondent number 1, respondent slash opposite party number 1. Considering the nominal period of delay, we are inclined to condone the same. The IA is accordingly allowed and disposed. The delay is condoned and the IA is accordingly allowed and disposed of. Then there is a IA for dispensing with filing of certified copy.
Yes, my lord.
That is the impugn order.
Yes, ma'am.
That all. IA 6118 of 2023. IA is allowed.
611.
Yes. So you accept notice on behalf of the.
Yes. Even some time for filing in account.
Okay. Have you served a copy of the appeal memo?
Yes.
You have. Okay. List for fresh admission. on 18th. 18/7/2024.
18/7. Obliged.
Item 26.
Yeah, my lord, the question, only question of limitation notice was issued, but it has returned with postal endorsement that no such person is found. In fact, the address given in the writ petition, in that address, your lordship had issued notice. So fresh steps required.
You take fresh steps. Sometimes the address is not complete. So you take fresh steps. How much time do you want?
Week's time, my.
All right. IA 8407 of 2023. As the limitation notice has returned unserved with the postal endorsement, no such person. Return to sender, inverted comma, reseta de deve, comma. Mr. Saswat Das, learned additional government advocate, seeks for 1 week or 2 weeks.
2 weeks, your lordship.
Because you have to ascertain the correct
Ascertain the address. Fresh
is granted 2 weeks time to file the fresh requisites along with correct address of the sole respondent.
Sole
Sole respondent / opposite party. List the case. List the case after 8 weeks. Can be listed after 8 weeks. If requisites are filed, notice shall be issued, fixing a returnable date after 6 weeks. List the case. Date fix kar diyan, 8 weeks.
Item 27.
27, my lord. Notice on limitation issued on 26/6/2024.
Somebody has appeared. Name appears.
And Mr. Sasibhushan Biswal
Yes.
is appearing. It's not there.
So after issue of notice is the first date.
My lord.
All right. Delay is there. Somebody has appeared but not present in court. What is the delay?
Delay, my lord, the delay is 796 days, but pursuant to the direction of the Honorable Apex Court in the suo motu proceeding, if the period is eliminated, then it is only 184 days.
The last date also nobody had appeared. They had last date we'd asked them to verify when any counsel has appeared. Thereafter the name has come. Kebe file korcheni wakalanama Mr. Lekhile. IA number 8575 of 2023.
25th June.
857. Stamp reporter kete din delay dekhile.
8.
All right. This IA has been filed for condoning the delay in filing the writ appeal. Although the stamp reporter has shown a delay of, calculated the period of delay to be 874.
800.
800 days, full stop. Mr. Saswat Das, learned additional government advocate, submits that in view of the, give that citation please, reference. In view of the decision of this, of the Apex Court in the case of suo motu.
Suo motu proceeding.
So and so.
During COVID period.
So
the delay for the period from 23/2020 to 31/5/2022 was condoned by the Honorable Apex Court. 23/2020
yes
to 31/5/2022.
31/5/2020. The period from 20th March 2020 to 31st May 2022 shall not be taken as shall not be calculated as calculated to be a part of the delay, and hence the delay shall come down to how much?
184 days.
184
Present
days. None appears for the respondent in spite of a valid notice. So the names of Mr. Sashibhushan Biswal and Mr. It is for respondent one, na?
One.
Indicated in the cause list. Considering the submissions of Mr. Das, the learned additional government advocate, and the decision of the Supreme Court in so-and-so case, Supra, we, in the interest of justice, we are inclined to condone the delay in filing the writ appeal. The delay is condoned and the application is allowed and disposed of. We'll fix it for fresh admission. List the case for fresh admission on 18/7/2024.
Item 28.
Item number 28, there is a delay, my lord. But clerks may see the order, my lord, which is impugn before my lords. Clerks may see page 23. 24 is the
23.
This order was covered by judgment in past in WPC number so and so. This order was challenged in writ appeal number 687 of 2022. The lordship has passed the judgment.
So we'll issue notice.
Yes, my lord. So your lordship may issue notice on the question of my lord's judgment.
IA 8734 of 2023.
That my laboratory technicians having not qualification.
IA 8735 of 2023.
It's a lab technician matters. Other matters have not been listed.
Not listed. Your lordship has adjourned all those matters after disposal of this writ appeal. Now, other matters notice has been issued and other councils have appeared. These three matters notice.
Issue notice on the question of limitation, fixing returnable date after 6 weeks. Requisites shall be filed within a period of 1 week.
Well,
All three collected.
All three are same. List this case already. There's an order probably to list. Yes.
Item 29.
I have filed objection to the limitation petition, served copy to the appellant, and also have served copy to my petitioner.
my lord, in the objection filed today, my learned senior friend had attached 3 letters which are not within my knowledge. I will have to take instruction on this. Because he says that it is stated that after passing of the impugned order, there was communication and the department has written that we are going to take an appropriate decision on that. But in my limitation petition, because I got the instruction that the certified copy of the order was supplied by the learned counsel who was appearing for the appellant on 19/11/2023.
So you have taken a false stand.
Yes. Now, in fact, that order was also, that letter is also there. So I want to file an affidavit to that to clear that because it is.
We are making it clear that since you have taken a false stand, you must have taken a stand that you learned about the order when you received a certified copy of the order.
That is exactly what I have stated in my petition.
That can be a ground for dismissal of your limitation application, even if you may have something bona fide.
But these correspondence was not within my knowledge. So
Not your knowledge.
Sorry.
Knowledge of
Yes,
the.
so I have to take instruction on that and.
No, but were you not heard?
Pardon?
Were you not heard in the matter?
In the writ petition, he was not the lawyer.
Writ petition.
No, not the lawyer, I'm saying.
No, I was not the lawyer.
He was not the lawyer.
But the lawyer was there.
Yes.
Lawyer was there. And he sent the certified copy of the order on
1311.
No, so ground is taken lack of knowledge or lack of certified
So
copy?
therefore, we have taken that from the date of receipt of the certified copy order,
Okay, then.
we took a decision and ultimately the appeal was filed and there is a delay of 74 days.
Whereas on the very first day, we communicated the certified copy.
Oh, but there is a delay of 74 days only.
Yes, but my lord, the question is, my learned friend was going to, he has shown me the letter of the lawyer concerned. He has advised them to carry it out, my lord.
That is different. The question is of delay. We can dismiss
My lord can see for a moment that first letter that was communicated to me.
No, letter is not material. The question is of condonation of delay. Delay of 74 days. Can we think of dismissing a limitation petition?
My lord, the statement that was given in the condonation application delay petition is completely incorrect, my lord.
What is the statement, Mr. Rath? He says certified copy of the judgment was communicated.
My lord, I communicated the certified copy. Petitioner communicated the certified copy.
Communicated by the learned counsel. He cannot challenge the order with your certified copy.
My lord, the certified copy of my lords.
No, I'm just saying what ground he has taken. That if you look at it, it is not incorrect.
Not false.
Yes, not false.
The division office is to take a decision that was communicated to the circle office.
Certified copy
So
was
there was a
communicated to
communication
learned
gap between
counsel.
the circle of
Because last time I took time to file it, today file it.
E-filing system is
there is a delay of 74 days and this is LIC of India. So
At page 8.
matter can be decided on merit.
Just a minute. Annexure at page 8. They communicated that received the copy, they want to comply it. They wanted 15 days time. Thereafter, my lord, another letter was communicated, another 15 days time.
to take appropriate decision.
Yes, not to comply.
My lord, the order of the Honorable Court was within their knowledge. And that's why they wanted to take some steps. But in the limitation petitions, they say that after we got the copy from the advocate, we could come to know that. It's a deliberate incorrect statement.
Where have you stated that you had sent certified copy of the order?
My lord, that is Annexure A by 1, my lord, can it be seen at page 8?
Annexure 1 is a copy of certified copy. It is not a certified copy. And 74 days delay, Mr. Counsel, when you appear for the appellant,
yes,
and there is 3 days delay, then we will consider whether that is to be condoned or not.
We will say you have vehemently objected because you have vehemently objected. But because of the...
I understand, my lord, but the ground I am only taking aback by the ground they have taken that we got the but in fact...
No, they don't say intimation,
Right,
they say certified copy.
All right, for that we will impose cost, 1,000.
This IA has been filed, IA 8810/2023. This IA has been filed for condoning the delay of 71.
4 days.
74. Stamp paper.
I've said 75 days.
74 lectures.
71 days.
Anyway, 74 days. All right. Let us accept 74.
Delay of 71. No, stamp reporter has indicated 71.
74.
71 delay, 71 days delay in filing of this writ appeal. The appellants, it has been stated at paragraph 2 of the interim application that the certified copy of the judgment was communicated by learned counsel appearing for the appellants on 19/11/2023, after which the matter was referred to the corporate office for seeking legal opinion, and thereafter the appeal has been filed. And since the delay and the delay of 73 days in filing the writ appeal has been caused due to what they have 73 days in filing the writ appeal due to official formality, the same may be condoned. Full stop. Mr. J.K. Rath, learned senior counsel appearing on behalf of the respondent, has vehemently opposed the application, stating that the copy of the judgment had been communicated to the appellant.
Yes, ma'am.
Appellant on when?
That was received by them.
Appellant in the month of September 2023.
No, my lords, that was received by them on 26 September 23.
In 26 September 2023, after which they had responded stating that they needed time up till October 2023 to take an appropriate decision. Full stop. Considering
Second also letter, they another 15 days they wanted. Page 10.
page 10. No, that is all right.
That is on 25th of October 2023.
And
They
they had
wanted.
again written to the respondent on 25/10/2023, stating that they are not able to take a decision by end of October 2023 and needed 15 days and needed time up till 15th November 2023 to take an appropriate decision.
Yes, ma'am.
In the light of the judgment of this court. Full stop.
Again on 10th, page 12.
This was followed by another letter dated 10/11/2023 to stating that they needed time till 30th November to take appropriate decision on our part. Take an appropriate decision. Stop. Considering the period of delay and that considering the period of delay and as the letters referred to by Mr. Rath, learned senior counsel, does not in any way contradict the reasons cited in the IA for stated in the IA for the reasons for delay in filing the writ appeal. We are satisfied that a case is made out for condoning the delay for in filing the writ appeal. The writ appeal is the IA is accordingly allowed, but subject to payment of cost of ₹1,000 to the respondent within a period of 3 weeks, 2 weeks. Within a period of 2 weeks. Full stop. The IA is accordingly allowed and disposed of. List writ appeal, list for fresh admission after. List for fresh admission on 3
weeks.
On 31st. On 31st July 2024. The objection is taken on record. Hello?
Item note 30.
In item 30, Lordship has issued notice on limitation on 15/5/2024.
Yes, note of the registry indicates that neither NADIO nor unserved notice is back from the sole respondent. Full stop. List the case on 7/2024. In the meanwhile, registry is directed to ascertain if any counsel has appeared on behalf of the respondent and to attach a copy of the postal delivery
Tracking report.
Postal tracking report to the file, to the record. Yes.
Item 31.
Although there is a delay, but there was a direction of my lords directing the land council for the respondent to verify whether the law decided in case of this Ravindranath Mahapatra case, the judgment delivered by this honorable court, whether the case of the petitioner
Ravindranath Patnaik.
Ravindranath Patnaik, I'm sorry. Whether the case of the petitioner, that was the direction. Because he has claimed for regularization of his service against a post. In fact, there is no such post, no sanctioned vacant post, and that was the specific stand taken in the counter affidavit. And there is also no specific finding of the Honorable Single Judge to the effect that the petitioner was continuing against any sanctioned vacant post. However, the Honorable Court has directed to regularize his service, considering the fact that he has been continuing for a longer period of more than 24 years. That is the direction, madam. However, the law decided by this Honorable Court in case of this Ravindra Kumar Patnaik, your Lordship have laid down a principle that the person claiming regularization has to demonstrate that he has been holding a sanctioned vacant post and continuing for that post. Here there is absolutely no finding in the judgment of the Honorable Single Judge that the petitioner was continuing against any sanctioned vacant post. Although a stand was taken in the counter affidavit that no such vacant post is available. He was only a daily wager and he was appointed on daily wage basis.
So why had we asked him to consider that decision? Because this is for conversion.
Today, my lord, is for orders. My lord, there are two IA interim application is there. One for dispense with the filing of separate copy, another for condonation of delay. My lord, as regards the filing of the certified dispense with filing certificate.
No, let us see the order, impugned order.
Impugned order, my lord. Before that, my lord, may I pray, my lord, with as regards it may be delay point may kindly considered first, because as regards the delay point, my lord, your lordship's order is squarely covered to my case. Your lordship have a glance. Here, my lord, the order was the writ application has been disposed on 5/5/2023, and direction that within three. My lord.
We must make one thing clear to you and
My lord.
every member of the bar.
My lord.
That you can't tell the court to confine the hearing on a particular point.
My lord. For today is for
It
orders.
is not that we,
Yes, yes,
in
my
each
lord.
and every case, we have to hear piecemeal and decide
No, here-
piecemeal, like one limitation petition, consider limitation petition, then come to merit.
My
We can deal with
Yes, yes.
both the
But
aspects
my lord, since it is
together.
under orders, my lord,
Don't
I
do
have,
it in future.
yes, sorry, my lord. Since it is under orders, I have an impression that the matter.
Page 80 of the writ appeal. 80.
Step 5. Yes.
My lord. Page 82. May I take your lordship to page 82?
Yes, let him submit
Should I-
on the point of limitation.
Yes, limitation. Here, my lord, lordship will find the application, the writ application has been disposed on 5/5/2023, and with a direction that you are required to take a appropriate decision with regards to the absorption of the petitioner, because he has already rendered about 22 years of services, and that was within a period of 3 months. When, my lord, it was not considered, the petitioner, the respondent had filed an application for initiation of contempt because of non-implementation of the order. Thereafter, it has been disposed of with another application with an order that you are required to dispose of in other by granting.
filed a contempt
Contempt
application.
petition, my lord.
That was
And in
disposed.
contempt petition, the order has been passed, they are required to implement the order within a period of 1 month. Thereafter, my lord, I have filed, when it has not been implemented, another contempt petition has been filed. Thereafter, my lord, they have, what I find from their interim application petition, thereafter they have processed. After a long gap of 5 months, 6 months, they have processed that whether the writ application, the writ appeal will be filed or not, as will be revealed from the interim application which they have filed for condonation of delay. Now, your lordship will find that I have also filed an application for objection to the interim application for condonation of delay, where I have stated, your lordship will find they have taken a point that there is an official delay for official procedure, and for which they took, there are, even though there are 302 days delay, but they have said 271 delays. But in fact, there is more than that. And apart from that, when the certified copy of the order has not been filed, the delay also will continue. It is not that it has been ended on 302 days. Now, my lord, the lordship will find from the interim application order the point which they have taken for condonation of delay. May I permit it to place my report? My lord, they have said in their application,
Considered time of admission. And both the. So we will consider this aspect at the time of admission.
my lord, we call this.
One of the similar matters posted to Mr. Das?
No, it is no similar matter.
No, no.
When do you want? We will hear this appeal on merits and your limitation petition, both. When do you want?
15 days, my lord.
15 days.
Dispensing with, you cannot have any objection. Dispensing with filing of the certified copy.
But that delay will continue. My lord, may kindly.
Delay will continue if that IA.
Yes, unless, if your lordship will direct, then it will.
If the IA is there.
IA is there.
Yes.
They have filed IA.
Yes. IA 826 of 2024. This IA has been filed. Allow that for the legal order. And IA 827 of 2024. This IA has been filed for condonation of delay of 272 days. For condonation of delay of 272 days and filing of the writ appeal. Heard Mr. Saswat Das, learned additional government advocate, and Mr. S.P. Jenna, learned counsel, appearing on behalf of the
Respondent.
sole respondent or respondent number one?
Respondent.
Sole respondent. The question of condonation of delay shall be considered at the time of admission. List the case for admission on today is 10th, 31st of July 2024.
Item 32.
Hello, 32. I am appealing for the respondent. Which time for filing objection, my lord?
That matter you have already taken twice or thrice. This one?
No.
Then?
No, this is the
I
Another
received a
one.
notice.
has to be
Another one.
as similar matters. He is appearing, so your lordship.
That is
all the matters that.
No, are they similar?
Yes.
Then we can post to same day. Otherwise, every day the same thing
Yes,
we will
madam.
have to consider.
Around 200 matters are there.
You are appearing in 200 matters.
Notice already issued anywhere about 15 or 16 cases.
No, then we can post to one day. That is what I was asking. Are
That
you
is my
aware?
lord, third week of July, my lord. Putable third week of July.
So is there any matter is coming?
No,
No.
madam. All the matters notices have been issued, and some cases he has appeared.
In that we have granted him time to file objection.
Yes,
That's
madam.
what I'm saying.
So all
Third week
matters
of
are
July
being
or
taken to third week of July.
All right.
So what is the delay?
Here, madam, delay, madam, the order was passed on 6/10/2023.
One, I think we have already condoned also, if I remember correctly.
Around
One case, your lordship, delay is condoned. In other cases, your lordship, because my lord, they have filed the review and the writ of
Which case delay has been condoned?
that is one
169 days delay.
Balaram Parida.
Balaram Parida. That
In
is
that
the,
read appeal, I can verify that read appeal and I will submit that read appeal.
Anyway, we
In-
granting him 1 week time to file.
Well,
2 weeks. One man from the Mayurbhanj. 2 weeks.
Want to trouble that man from Mayurbhanj to come and file a.
Retired again, though. No problem.
All right. Mr. Sushant Kumar Mishra, Learned Counsel, you're filing Wakalatnama
Yes,
here?
yes. Today I filed.
But it in the registry.
He submits that he has instructions to appear on behalf of the respondent number 1 and shall file Wakalatnama.
Only respondent was, sole respondent.
Okay, sole respondent and shall file Wakalatnama in course of the day. He wants 1 week time and he prays for a week's time to file an objection to the interim application for condemnation of delay. Full stop. List the case on 24/7/2024 to enable him to file his objection.
Obliged.
Item 33.
This matter was yesterday before my lords. The lordship wanted to know that rule. The lordship wanted to know that rule.
Which rule?
Just I'll refresh my lords that matter relating that promotion during pendency of departmental or criminal case. I have given that date at my lord. Why you have not considered? Because you have not completed that residuary period. He was given promotion after his act. Your lordship wanted to know that residuary period. Your lordship may see rule 6.
No, but why are you taking this case on merits? Acha.
No, my lord. Yes. May I refresh my lord's refresh? Tell us, see my date chart.
Just. Yes, there is provision for relaxation. Can be considered.
No, that is the rule. I will come that relaxation. Your lordship has got that rule 6.2. Rule 6.2. 6.1. Sorry, 6.1. He has worked at least 5 years since.
That you have seen.
Yes, ma'am. Then your lordship may turn to rule 20. Rule 20.
Yes.
There is a relaxation provision. Again, I will draw my lord's notice. My lord's for a moment, your lordship may see my date chart for a moment. Why I am saying, my admitted fact was appointed on 23/8/2010 against the vacancy of 2005-2003 in compliance to direction part in another writ petition. This is the position, madam. The date of his appointment is 2010.
So when was his junior promoted?
Yes, ma'am. That is admitted person in 2014.
2014.
Madam, there is no dispute about it.
So it's a matter of only 6 months or something.
Yes, I understand. But we have given him promotion. After his acquittal, we have given him promotion from 2018. So yesterday, your lordship asked me that to show that rule for that residual period.
So all right, we can today. What is the delay?
Delay, my lord, 900 days.
900 days.
900 days.
If your lordship will dispose of that writ appeal, my directing will give him promotion on completion of 5 years. That can, if that only he will be affected only 2, 3, 4, 6 months.
He will complete 5 years by 2015.
All right, then.
Yes.
Well, the present order is being passed with the consent of the parties. What's up? IA number 1962/24. So this application has been filed for condonation of delay of
900 days.
In fact, there will not be 900 days. Some period will be exploded because of one of Supreme Court's decision that
900 days without excluding the period in terms of the Supreme Court's orders passed in suo motu so and so. Welcome. So stop. The in view nature of the dispute and considering the submissions advanced at the bar, we deem it proper to condone the delay and address the issue involved. Full stop. The respondent is a member of Odisha State Finance Service. In a criminal case, he was convicted.
acquitted.
No, initially convicted, thereafter
no,
acquitted.
He was acquitted.
There was
No conviction.
there was a
Oh, sorry,
criminal
sorry.
case
Yes.
lodged against him, because of which his case was not considered for promotion to what is OTNAs?
Odisha Taxation and Account Service.
Odisha Taxation and Account Service bracketed OTNAs cadre.
And OFS?
OFS Odisha then subsequent promotion is Odisha Finance.
Subsequent.
When the DPC was held, there was a criminal case. By the Departmental Promotion Committee in its meeting held on 4/12/2014.
13 million.
13. Oh, stop. 13. In accordance with, there is some rule.
Yes, ma'am, I have given that rule.
Where is that rule?
I have given that. Yes, ma'am, that rule.
Which rule?
That Odisha Taxation.
No, which? It says that case shall not be considered if criminal case.
That rule 6.
Rule 6.
Odisha Taxation Account
No, no.
Service. Rule
Criminal
6.
case is not there. That is for eligibility.
Yes, that eligibility criteria that one must have completed 5 years. 6. Rule 6(1).
So that we have seen where in case of Barik, we have, in Barik's case, there was a decision which.
Well, that GA department notification dated 18/2/1994. That is the
Yes.
office
The light
memorandum
of an office memorandum
to 1994.
issued by the state of Odisha dated 18/2/1992.
94 miles.
94. So stop. The second DPC meeting for the year 2016 was held on 23/11/2017. The petitioner's case
the respondent's case was not considered for the same reason in the said DPC meeting also. So, in the meanwhile, based on the recommendations made by the DPC for the year 2013 and for the year 2016, the officers of OSFS cadre were promoted to the rank of to OT and AS cadre. Some of them were juniors to the petitioner, respondent. The junior most officer who was given promotion to the rank of OT and AS cadre
on 7/2/2014.
The junior most officer given promotion based on the meeting held on 4/12/2013 was given such promotion with effect from 7/2/2014. 7/2/2014. Stop. The petitioner, the respondent, was acquitted in the vigilance case, in the criminal case, on 24/3/2023. A departmental proceeding was also initiated against him, which had resulted in imposition of punishment of censure by an order dated 7/12/2023. Stop. The respondent has been given promotion to OT and AS cadre with effect from 1/1/2018. After his acquittal in the criminal case by a notification issued on 31/1/2024. Stop. With a grievance that he was wrongly, with a grievance that merely because of the pendency of criminal case and departmental proceeding, his case for promotion to OT and AS cadre was not considered, and therefore he was entitled to promotion to OT and AS cadre with effect from the date from which an officer junior to him was promoted. He filed a writ petition giving rise to file the writ petition, that is WPC number
27269. 2020.
Stop. It is noteworthy that the respondent entered into OSFS cadre when?
On 23/8/2010.
On 20?
3/8/2010.
23/8. Sorry, not OFS cadre.
But appointed as Inspector of Commercial Tax.
Was Calicut? No, entered into was appointed as
Inspector of Commercial Tax.
Inspector Commercial Taxes on 23/8/2010.
Yes, ma'am.
So stop. The Odisha Finance Service is governed by the, this is something else. This is this cadre rule.
The Odisha Taxation and Accounts Service 2011.
No, but this Odisha taxation will not, that will govern whether Odisha
Yes.
of
Yes, ma'am.
Finance Service.
Next promotion is Odisha Taxation and Account Service. This is governed by the 2011 rule.
No, Odisha. No, his promotion to the rank of, he was appointed in 2010.
2010.
He was entitled to, he could have been promoted to the rank of OSFS.
Now, Odisha Taxation and Account Service. Then my OFS. Next promotion is OFS. This first promotion is Odisha Taxation and Account Service. That is governed under 2011 rule that I have given that copy.
No. So he will be promoted under category 4B.
Yes, ma'am. That is, yes, ma'am. Yes, ma'am. Your Lordship.
So what cadre was he in?
B.
No, B says Odisha Subordinate Finance Service cadres and such other categories.
Yes, is Odisha Subordinate Finance Service. Commercial Tax Inspector is Odisha.
All right, we will examine, we will dictate it tomorrow.
Well,
seems I have committed some mistake in my dictation.
No, my Lordship, that's not, no mistake is there. No mistake.
No factual error.
No.
All right. I mean, I will examine and
yes,
and we will do that. 5 years we will grant you.
Yes, ma'am.
Modify that.
So what will that date be?
Then your Lordship can then 23/8/2005 years, 23/8/2015 onwards any date after completion.
Otherwise, you've given him from?
We have given him promotion from 1/1/2018.
Yeah, right. Yes.
All right.
Ma'am.
Item number 34.
My lord, notice has been issued. The question of delay. While a friend has appeared. Here there is a delay of 460 days. My lord, so far as the merit of the case is concerned.
How much money?
Delay, my lord, and in paragraph 3, nothing has been mentioned.
Alright, depending on 100 rupees for each day.
Yep.
There must be some method. Yes. Otherwise, in one case, 10,000, 1,000. So because so beyond 100, 00.
I have filed my objection.
You are getting so much of money, Mr.
And the case can dispute the limitation also. 460 days delay, no resignation assigned. Kind my lord. Paragraph.
Therefore, we are imposing cost of and that will be
No
paid to
resignation
you.
assigned, my lord. I have filed my lord's order. I have given my lord's own order. But I dismiss the appeal on ground of delay. I have filed objection, including my lord's order also. Including my lord's order. That because of delay of
Where is that order?
quote the annexed A by 1 to my objection. That's a flag F. 470 days my lord dismissed.
Same matter.
Same matter. No, so not same matter.
Not
but
same matter.
Not same matter.
Then we can do it.
But the issue is, my lord, the
No,
delay.
but you are getting 46,000. As you wish.
As your lordship.
Yes.
Your lordship's offer could not be refused. Your lordship's offer could not be refused.
Earlier lordship used to impose 10 rupees per day.
We are now 100.
And no region assigned also.
460 days, then he is right. That's no.
So Mr. Mahanti, should
There
you
is-
condone or not?
My objection not to condone because retired person only for revision of pension. And similar matter lordship already allowed to dismiss. Similar matter.
Same subject matter,
Same subject matter. Lordship read person file challenge or tribunal. Read was dismissed.
All orders of tribunal are not the same.
Exact same order, same issue. They are dismissed, and thereafter government complied all the orders except this only 2 cases. Except 2 cases, all orders they are given the benefits. That will
You
produce
will
also.
also be given the benefit. We don't know. So you are getting 46,000 plus order also.
Haji lordship.
Can only pray, my lord. Let it be 10,000. 46,000 is too much.
Let us follow. Now we will be following a uniform rule.
In fact, yesterday in one matter, your lordship had
10,000, yes.
10,000.
That was the delay was not that much.
The delay
And
was
still from tomorrow, today.
delay was more than this, my lord.
More than this. Maybe we should.
We can recall that.
Only request.
Yes. There is delay of 460 days in filing the present writ appeal. Stop. Upon perusal of the averments made in the application, made in this application, we do not find a satisfactory explanation for condonation of delay. Stop. We, however, cannot ignore the natural delays which are caused by the state government departments because of the movement of the files in such matters. Full stop. At the same time, we do not approve the casual way in which the state government departments deal with the orders of process filing of appeals. Full stop. Taking into account totality of the circumstances, we deem it proper in the interest of justice to condone the delay upon payment of cost of rupees 46,000 to be paid by the state to the respondent within 2 months. Full stop. List this appeal for admission on 10 weeks.
Item 35.
My lord, during pendency of the writ appeal, I have filed an IA. The rationale 8 after
No, whether this is for conversion or delay.
delay 71 days.
1 day.
71 days. 71 days delay.
All right. Who is for the condoning?
Yes, no, no. I don't have one.
There's some private opposite party also.
Private,
Who's Mr. Manaspati? This is item 35.
yes, private opposite parties are there, my lord.
Where are they?
I don't know, notice has not been yet issued to the opposite parties.
Notice was issued, my lord.
This has been issued. Yeah, for the
It is issued, huh?
You're there? Delay of only 71 days. You're Mr. Behra?
My lord.
IA 3883 of 2024. This interim application has been filed condoning the delay of 71 days. in filing the appeal. Heard Mr. P.K. Behra, the counsel for the appellant petitioner, and Mr. Manaspati.
Yes,
Mr. Manaspati, learned counsel appearing on behalf of the sole respondent, or there are some other respondents also?
No, my lord, private topic, if you also look at the number of performer respondents, those were there because if losses.
He is the contestant.
1 to 5, my lord. 1 to 5 appearing from Mr. Patti, my lord.
Mr. Pati, you don't know whom you are appearing for? You don't, please check, it's all right.
Notice was
Take the file there.
1 to 5.
Mr. Manaspati, learned counsel appearing on behalf of the respondents opposite party number 1 to 5. Full stop. Considering the nominal period of delay and the explanation offered, comma, we are satisfied that this is a fit case for conducting the delay in filing the writ appeal. The delay in filing the writ appeal is condoned. The IA is allowed and disposed of. Fresh admission, we this is the case of fresh admission on 18/7/2024. You are there for whom, Mr.
Yes, I am from 6 to 12 minutes.
Yes.
Item 36.
My lord, there is delay in filing appeal, your lordship. A judgment was pronounced on 22/12/2023, your lordship, but the copy available in the website as well as certified copy on 24/4/2024, your lordship.
And
How much?
my lord, I have mentioned 30-day delay, 30 days, your lordship.
Office says 156. Why?
My lord, judgment copy was available on 24 for 2024, your lordship.
Oh, so you had not filed the copy along with the appeal? Had you not filed the copy along with the appeal?
Judgment copy was not available. My lord,
So how have you calculated 30 days?
my lord, from 24 for 2024, your lordship.
Oh, okay, all right.
And for the respondent.
Do you have any objection?
My lord, I have no objection, but my lord, the ingredient of the advertisement has not been complied.
No.
That is on merit.
Merit.
We'll hear you on merit. We are asking about
Delay can be controlled.
this IA 4618 for 2024. The IA has been filed for condoning the delay of 154 days in filing the writ appeal. Heard Mr. Jagavanthu Sahu, learned counsel, appearing on behalf of the appellant, and Mr. A.K. Naik, learned counsel, appearing on behalf of the sole respondent. Slash query petitioner opposite party de deve. Considering the averments in the IA for the reasons considering the averments in the interim application for condoning the delay, we are satisfied that it is a fit case for condoning the delay in filing the writ appeal. The delay is accordingly condoned and the IA is allowed, full stop. List the case for fresh writ appeal for fresh admission on 18/7/2024.
I have filed for interim order, your lordship.
Fresh admission on that day we will take it up?
My lord, next week, your lordship, because they are going to make a fresh selection list, your lordship.
No.
So 18th is which date?
Very difficult. Not when we take up for admission.
You asking for next week? We've already ordered for next week.
Yes.
Yes.
Item 37.
There is a delay of 99 days in filing the appeal, my lord.
Notice has to be issued.
Yes, my lord. 1, 2. Only
I am appearing for 2 to 7.
Well,
There are
private respondent are supporting respondent to me. I pray notice may not be issued to them because some
But not required.
not required because they are also possessing the partnership. Only one I will take notice, madam.
Only one.
Only one.
Mahanadi Court feels all right. Mr. Biswal, learned IA for IA 4623 24 dispensing with, allow that. And that IA is allowed. IA number 4649 of 2024. This IA has been filed, this interim application has been filed for condoning the delay of 99 days in filing the writ appeal. Full stop. Mr. Anjan Kumar Biswal, learned counsel for the appellant, submits that respondents number 8 to 13. No,
215.
Huh?
215. 7 so thile city opposite party thile. They are the pro forma opposite party there.
Respondents number 8 to
15.
215 are pro forma respondents, full stop. And pro forma respondents, Mr. T. Devakanta Mahanti, learned additional government advocate, appears on behalf of the respondent number 227. Issue notice to the respondent number 1 by registered post with AD, returnable within 6 weeks. Requisites in the matter of condonation of delay. Requisites for which shall be filed within 1 week, within 3 days. List the case.
6 weeks.
After 6 weeks.
I may be pardoned, my lord.
26.
I may be pardoned, my lord. Item 36, appeal memo may be solved, my lord.
I will serve your lordship.
For admission, item 38.
Item 38, may I please take up Monday or tomorrow? I have taken consent of my learned senior.
There is nothing, Mr.
Taken
Whether
consent.
the order has been complied with.
No, madam. It's an order beyond the scope in the contempt.
That is beyond their scope.
Yes.
Any of
Monday, sir.
Why are you praying for Monday?
I am not prepared in this case, sir.
Monday.
Or tomorrow, if Lordship may call it tomorrow, I am also.
Not tomorrow, my lord, will it come on Monday?
Monday.
My lord.
Item number 39. Put to please.
May I please, my lord.
What is this?
Lordship, on 26/6/2024, even though Lordships have not reflected in the order, Lordship had directed to take instruction with regard to the framing of the rules, because after the amendment, it is then the word is prescribed. It is now I've taken instruction. So the draft for this rule is already ready, Milords, and after waiting, it shall be final within 4 weeks. And in the meantime, we will also call after 4 weeks. But we will not, in the meantime, no transactions shall be made till finalization of the rules, Milords.
I have the affidavit that I have not made any transaction.
No transaction, it shall also be not done, Milords.
All right, we are just adjourning it for
4 weeks, Milords. In the meantime, we will frame the rules.
As jointly requested the matter on 4 weeks. We have been informed that the state of Odisha is in the process of amending. Oh, you are challenging an act? No?
Yes. They are
Yes,
coming
sir.
with framing of rules.
I'm not saying it.
Item 40.
May I please, Your Lordship?
Yes.
Your Lordship, I have, as per the instruction of my client, Your Lordship, the authorities have assured that the bank accounts are to be released. Hence, hence the appellant seeks permission to withdraw the present writ appeal, Your Lordship.
And counsel for the appellate, considering the circumstance, considering the developments subsequent to filing of the present appeal, seeks permission to withdraw. Yes.
This is the matter, my lord. Further four read appeals are pending. After order of this annual court that a review order was passed, on last occasion, Your Lordship has asked me question whether any separate read appeal has been filed or I have to file an amendment. In fact, a separate read appeal has been filed. That is read appeal number 300 of 2024. Read appeal number 300 of 2024.
Against review order.
Against that review order, another read appeal has been filed. So both the matters can be taken up together. Read appeal number 300 of 2024.
Present inter-court appeal has been referred against an order dated 24/2/2023 passed in WPC number 14172 of 2018. First off, we have been informed that a review application was also filed seeking a review of the said order dated 24/2/2023, which has been dismissed by an order dated
Not dismissed, allowed, that review application has been allowed by order dated 14/12/2023.
14/12.
the review application was filed, which was allowed by an order dated
14/12/2023.
14/12.
14/12/2023. So, the said said order dated 14/12/2023 is under challenge in WA 300 of 2024.
Well,
So, this appeal along with WA 304.
and also I played three other read appeals there, but this is a common judgment. Three other read appeals, 1791 of 2024. Yes, I'm giving that.
We have
I'm
also
giving
been
the
informed that against the
common order.
said common order dated 24/2/2023 passed by the learned single judge. Certain other following writ appeals have been filed which are pending. So stop. List this appeal along with WA 300 2024 and
Three read appeals have given that one.
on when
But all those copies the government has filed, it is served on us
Yes, in course of the day or by tomorrow.
by tomorrow.
By tomorrow,
when
by tomorrow I'll serve.
when do you want?
You'll also may fix any date, madam.
I think next week or week after is day.
My lord's convenience, any date.
15?
Yes, madam, I don't. 15. Date was proposed.
Item 42.
Your lordships last time had asked us to give copies to the union and they were supposed to come up with some instructions.
Already, my lord, received last occasion, my lord. I pray, my lord, on some more time will be granted. 10 days time at least.
This about
What is this
Yes.
matter?
That certificate matter, if your lordships remembers that. The certificate, dating of the certificate.
Oh,
And not the single judge has been pleased to dismiss the appeal, the constitutive res judicata, not on the merit.
certificate to be date of passing.
Yeah, not of
passing.
the examination, but the date on which
Issue
they
of
issued the
certificate.
fresh certificate.
Oh,
My lord. On 27, I have received the copy, my lord. I have already sent. I have yet to receive the instruction specifically. That's why I
has to give you
interest.
instruction? Who has to give you instructions?
OP number 213, my lord.
Who is OP number?
That National Institute of Open School that from New Delhi, my lord. I have already sent that copy. That
All right. 2 weeks further time is allowed for learned council representing
for OP number 213.
2 and 3 to seek instructions. Mr. Matter on 2 weeks.
Item 43.
Here.
Yes, ma'am.
Yes.
Madam, one password, my file is missed. One password. That I am giving that.
Yes.
My somehow taken from here.
Got it.
Yes, sorry, madam. Because that last occasion, Lordship has asked me that question whether that CCA rule is applicable or that PMA rule is applicable. I have got, I'll just draw my Lord's notice to Police Act and the judgments of the Honorable Apex Court as well of this Honorable Court, that they have said since this is a special act and the rules have been framed under Police Act, so that CCA rule is not applicable. Lordship, I see that section.
No, whether there is any decision.
This decision is there. This decision of this Honorable Court as well as of the Court of the Honorable Apex Court also. I'm giving that. Sorry, madam, one copy of.
What is the name?
One judgment of the Honorable, this court and another of Honorable Apex Court. My lord, two judgments there, one copy, my lord.
But
that in that case, your lordship is holding that one.
In Delhi case, there was DPPA rules.
Yes, ma'am.
Here you don't have any rule.
We don't have any rule, but that your lordship has seen that Appendix 49. In Appendix 49, there is a rule that we are saying that is the rule. Your lordship has not seen that Appendix 49.
That's Appendix 9 for.
Appendix 49 of police manual.
We have seen, but Appendix 49 is again kind of instructions.
Yes, my lord. Your lordship has seen that police. May I read my lord, Police Act, my lord?
Yes.
Your lordship has seen Police Act.
What about that Dharmananda Harijan?
That is the High Court of order of the Honorable High Court. In that case, your lordship has seen that there was a challenge that Rule 32 of OCS CC rule is applicable. That your lordship has held that CC rule is not applicable. They are guided by that PMR. Appendix 49.
So what are you saying here?
And another judgment I have
Another judgment?
that there also this honorable court said that they are guided by that PMR, not CC rules.
Oh.
For a moment, your lordship may see Rule 7 of, sorry, Section 7 of Police Act.
This Police Act is no more there.
1861 is there.
No. Police, yeah, the Odisha Police Act has not been enacted.
No.
See, there is a Supreme Court direction that all the acts should be.
My till that, no, that.
No, this Police Act is not there. This Police Act is not of Odisha.
No, this is the Police Act, not the Odisha.
So the Police Act has been repealed.
Yes, ma'am. That what I want to submit, my lord. Your lordship may see Section 7. Why I am.
Have you seen that? Whether this Police Act has been repealed or not?
No, my Police Act, not.
No, Police Act has been.
Not repealed yet. It has been amended from time to time.
Have you examined whether there is? Because all these states have.
So far as state is concerned, state of Odisha is concerned.
No, but we are finding from 2006 Police Act.
Police Act of 2006. That's the modern Police Act.
Till 2021,
That's
Odisha Police Act.
Beg pardon to intervene, my lord. My lord, this police manual has been derived from the Police Act of 1861 in 1940. My lord, this act being a special provision is a special act. It is protected under Article 313. My lord, although under 309, Article 309, the CCR rule has been framed, still then this provision, this manual is in effect, is in force as per Article 313, my lord. Laws in force before the commencement of the Constitution will be in force if it is not inconsistent with the Constitution. Under that article, it is also protected. My lord, the police is the subject of the state item, my lord, state list. But our state has not initiated any registration to replace this police manual. Some states of our country have replaced this police manual which was purely colonial. So it has colonial imprints, my lord. That is why some states they have replaced it. But unfortunately, our state has not initiated any legislation to replace that police manual. Still then, it is in force, my lord. And Police Act is also not repealed. It has been amended in 1949.
All right, yes. So you had the Police Act and police manual also. But after this, the police manual is has been prepared by the government.
Yes, ma'am, by way of resolution. These are the only executive instructions I can say.
Executive instructions. Now, where is this exclusion in the Odisha Civil Service rules?
Yes, ma'am, that is Odisha CCA rules 1962. That
So how does the provision under the that rule exclude police force?
Yes, ma'am, you'll also see rule 3. There are also see rule 3 1C.
C.
1C.
Yes, so you also.
Yes, my lord.
You are also of the view that the police manual
Police manual is
All right.
applicable in this case.
Tomorrow.
No. Next matter. Lordship.